Court officer, sir, can you hear me, sir?
We have filed it on 1st of April. There were some office objection. It has been cleared. There is an emergency to be heard this matter, sir. So I request it may be posted tomorrow.
What is the urgency? What is the urgency?
The judgment, we are challenging the judgment in writ petition 25528, wherein it has been stated that I'm an unregistered association. They have been asked to maintain the building. And I don't have bank account, nor I can able to collect any money, sir. And the entire building, chaos have been created, sir.
Only after vacation. After vacation, yes. It will go on 18th of June.
In
25th June. Tomorrow.
correction.
Tomorrow. Spoken to you.
All right.
Tomorrow will do.
Please come to the mic. You are already voice is weak, case is weak. Yes.
My lord, petitioners in the writ petitions are not the central government employees, my lords. Learned single judge held that they are the central government employees. So being agreed by the judgment, I'm here, my lords. Writ appeal, my lords. Kindly have it on tomorrow, my lords.
After vacation.
There is some urgency, ma'am.
No urgency, madam. Till vacation, after vacation, it can wait. Yes.
In
13th June.
Lord, memo for posting public interest litigation, my lord. The urgency is that, my lord, a earmarked public space in Tumkur city has been illegally occupied by few persons and they have started rearing pigs therein, my lord. So several representations given to the authorities have been left on, fell on deaf ears, my lord. They have started rearing pigs in the public park, my lord. Too much of inconvenience to the people who are residing in the vicinity, my lord.
After vacation. 26th June. 26th, if you want to submit memo, 26th June. If you don't submit memo, it will come earlier. Yes.
in one matter, my lord, that public interest litigation, it in a Gram Panchayat property, my lord, that one person created a Hakpatra and started
After vacation.
My lord, a fresh writ appeal under the cooperative societies matter. Elections have not been conducted to the cooperative society. And further, my lord, despite the government's orders, the CEO also has been suspended. My society is on the brink of collapse. The board of directors tenure has expired. The CEO has suspended. All I'm seeking is, my lord, urgent orders for reinstatement of the CEO and conduct of elections. There's a government order which says,
After vacation.
my lord, my position is that the entire society is in the brink of collapse. I'm not seeking anything else. At least the CEO could be reinstated, my lord.
If you
That is my-
succeed, then we'll revive your society.
My lord, because all my members are withdrawing their deposits and I'm.
Hold on to
literally-
this. Don't allow to collapse. Hold on.
There are no persons, my lord, the CEO.
See the queue.
Some and
See the queue
substance
behind.
that, after
Cannot go on
vacation.
arguing like that
Yes,
on memo.
yes, Mr.
Namaste, my
Complaint
lord.
in this case, my lord.
I'm party
Contempt.
person Sundaresh.
And one, yes.
We have a complaint in this case, my lord. In writ petition 5794 of 23, non-implementation of order of accused. Some we have made a reminder, some reminders also given and
After vacation.
kindly have it on tomorrow.
Tomorrow not possible. Yes, anything? Anyone? Yes.
My lord, this petition has been converted into PL on the last date, my lord, last week, my lord. In this matter, my lord, the school is being run by the fifth respondent illegally by encroaching stormwater drain. The building has no proper plan or approval, my lord. The BBMP has already issued a demolition order, my lord. But even after the issuance of demolition order, they are taking in students for the next academic year, my lord. We have already filed an IA in this regard to.
So permission to move the learner vacation. Permitted to move the vacation. It is listed today?
No, my lord.
Then move the learner vacation. Yes.
Contempt matter, my lords. It was dropped on the ground that the order has been complied. However, it is not complied, my lords. To that extent, I've filed IA.
After vacation. 26th of June. Yes. Yes, Mr. Partin. Yes.
Namaste, my lord. This is 2007 gratuity case by 73 to 75 years old litigants, my lord. Actually, there was a contempt petition. Subsequently, I have filed a review petition.
11th June. It is already posted on 11th.
You were absent.
11th June.
ಅಲ್ಲಿಗೆ ಬರ್ಬೇಕು.
This is a contempt petition, my lords. Respondents had filed an undertaking saying that they'll restore the revenue entries. This was a month back. Still no action has been taken.
No urgency. My lord, this matter pertaining to pensionary benefits, my lord. My lord, this
After vacation. 27th June.
My lord, this is a contempt petition and the order has been complied with. I'm filing a withdrawal memo.
Withdrawing. Which one? Serial number?
Serial number 16.
Tomorrow. You wanted to post it.
posted.
Serial number 60, my lord.
62. Learned and educated so and so on states that the order under contempt is complied with. In view of the statement, nothing survives in the present contempt petition. It is accordingly disposed.
That's all.
33, matter number 33, my lords. I'm for the respondent, my lords. I kindly pray for time, my lords.
Which one?
33, my lords.
Petitioner present.
What do you want?
Pray for time, my lords.
After it.
Lord, kindly permit me to appear online, my lord. Serial number 29.
Yes, 29.
29, my lord. There is instruction received today only, my lord, to withdraw the writ appeal. I'll file a memo, my lord. Could it be kindly taken up day after tomorrow, my lord?
After vacation.
Please.
My lord, serial number 26, my lord. My lord, I pray for 1 week time, my lord.
In which matter? Which matter?
Serial number 26, my lord. This matter is engaged to senior counsel. He's having some problem, my lord. Therefore, I'm seeking 1 week time, my lord.
After.
Serial number 34, my lord. Not feeling well, mechanically taken up after vacation. Serial number 34, my lord. Not keeping well, mechanically taken after week.
After vacation.
My lord, serial number 26, what happened?
53.
After vacation, Mr.
Great, my lord.
Serial
Yes.
number 53, my lord.
Yes.
I have some personal inconvenience, my lord, and health issues are there.
Pardon?
They have it on 53, my lord.
So what do you want?
They have
Time?
it After, yes, my lord.
After vacation.
Serial number 89 also. 89 after vacation. My lord,
serial number 67, my lords, after vacations, my lords.
67, what is it?
I'm for the accused, my lords. It is partly complied, my lords. 2 weeks accommodation, I'll completely comply with the orders of the Honorable Court, my lords.
All right. It was something to be told to the court? No.
It's partly complied, my lords.
After vacation.
Grateful, my lords.
Yes, ma'am.
See, this is serial number 58, my lord. After 3 days, the accused is getting retired. Like 30th of April, he is getting retired. And
She mentioned yesterday.
yes, yes, my lord.
We'll take a. Yes, we can take it. All out.
Me.
Yes, you're.
I'll bring my.
Some advocate is appearing?
No, no, my lord, I'm party in person. May I get my documents?
Take it.
Of my husband.
Complaints. She seeks.
Which is the disposal? This one.
Not in this matter was disposed of, Lord, after compliance of the order. Mr. Rashekar is appearing for the central.
Nothing is good. She is under the impression because of retirement, everything will go.
It has not complied in 5 months, my lord. My monthly maintenance is not yet started, but with the contempt court order, they have released my husband's all the pension benefits. He is getting regular pension, and he has got my medical cards are also not given. It is the payment of the medical, the receipt of the payment.
We have read the some IAs filed here.
Yes, IA number 4, the evidences, my lord.
In IA,
Kindly look into it, my lord. This is the receipt of the payment. This is not the medical card which they have given me in the open court. I can, may I? Can I give? Can I give this receipt?
so you are paid any amount or not?
Pardon?
Any amount is paid to you or not?
Sir, my monthly maintenance is not yet started. And as per the affidavit, what they had filed on 29th of August, that balance payment they gave me on January.
One lakh 47,000 is.
That was the balance of 5 lakhs. Further, they have really with this contempt order, they have released my husband's pension benefits. For there was an interim order of by writ I had filed on 7th September. That was overruled, like it is null, like it has been released. And I have removed my 125 MC case also.
We'll keep after vacation and impress upon them to ask them to pay the monthly maintenance. Nothing, immediately we'll keep on 31st of May. 31st.
Okay, madam.
Who appeared?
Central
government.
He can inform. I shall inform.
Your Honor, neither I'm getting finance nor the medical card. My son is waiting for his surgery since 25th of September. I have got all the documents from Command Hospital, Secunderabad and Apollo both. And I'm unable to get it, the surgery also done. Neither the finance nor the medical card, due to which I'm unable to reimburse the payment also, my lord.
Not a single installment is given.
No, sir. Since 1st of September till today, nothing has been paid to me.
No. You have admitted, amount has been paid. We have recorded it in the order. Please do not mislead us that way.
Sir, well, it is a misleading information which was given. It was the balance of 5,37,000.
That amount is paid to you. But don't say that no amount is paid to you.
That was, as per the affidavit, they were supposed to pay me before August 2023. And since I have, this is the second time I'm reviewing my MC 125. First on the order of Navy, I had withdrawn it in December 22. 21st of October, I had filed my MC 125. And just for 1/6 of payment has been given to me. And that too, even if I'm making it 60,000 into 12 months, it is coming 7 lakhs. They have given me just 5 lakhs.
For the 31st May.
Thank you.
31st.
For the bench, so they are my arms.
55, 56 before other bench. Sir, still number 1 to be mentioned matter.
In this matter, the appellants have completed their arguments, my lords. It's for the respondents to argue the matter. Can immediately ask because
this is that
VTU matter.
So arguments are left out still.
In fact, I have to comments, my lords. Immediately after, your lordship, adjourn to third for further hearing, my lords, on immediately after.
So what we were thinking was,
Please.
I was requesting Honorable Chief Justice that we can hear this matter. We have read the entire file twice now, lot of time at our disposal, so that we can craft our judgment during the vacation. Otherwise, during
And can your
vacation, we will
lordship
not
have
be
it
having
tomorrow,
any
my
work.
lords? I'll make myself.
You want to?
Only thing, my lord, Mr. Ravi, 2:30, we'll get ready and.
Yes. So we'll be able to finish today.
That's the only thing if it had after vacation.
No, I
Because
can-
there one other thing, my lord, there are Rajiv Gandhi University, various universities, various matters are there.
Those universities statutory settings are different. This has to be treated separately.
In this matter, only one act is.
Yes, yes.
involved.
Rajiv Gandhi
in fact,
University-
VTU Act is involved.
Yes, yes.
VTU Act is involved and various judgments. Under VTU Act, there are already 2 judgments. In fact, Rajiv Gandhi University was also.
Only thing is we can't close or keep reserve for judgment without hearing learned advice. All the parties have to be given.
In fact, Mr. Ravi Verma Kumar is traveling out of the country on lecture, I believe. Shall I further hearing immediately, my lords? After we.
They have in fact argued before me.
If you are able to complete within an hour or half an hour.
Only the pressure, my lord, last few days. That's the only thing, my lord. Or what I'll do is, my lord, just to assist your lordships, I'll give my note during the vacations, my lord, so that your whatever the points on first week of May, my lord, so I'll confine it to only to that. My lord.
While the submissions of appellants
are completed.
have been concluded. The arguments of the other side could not be comments for want of, or on account of paucity of time. In that view, parties do their respective learned councils request for time. Full stop. In view of the request and the circumstances obtained. Tend over to which date?
Any date convenient to your lordship.
11th of June.
For further hearing.
For further hearing.
Further hearing.
For further. Now, is it a practice?
At 2:30, we'll complete in 1 hour, my lord. We'll just.
2:30.
2:30, we'll just complete in.
2:30.
Much of.
Contempt matters?
Six. Mentions about that. Yes. I've seen that court officers handbook.
Seal number 2. Seal number 2, to P and Anja ready. Fresh contempt matter.
He's upset.
Still number 3, Mr. Ravishankar Shastri.
Hearing for the complainant, my lord.
After vacation.
Land of the complainant was my lord, illegally road was formed, my lord. Then, my lord, there was a direction to provide alternative land to the petitioner, my lord, within 3 months from the date of order, my lord, page 9.
Notice 1st July. Review.
R2.
R2.
Number 4, Mr. N. Sukumar Jain.
I accept notice for Lord R3.
You're for R3.
Yes, ma'am.
Direction was given to respondent number 20 to perform the road. There is no alternative road available to me.
No direction. 1st July.
Number 5, S. Ramurthy.
For the complaint, my lord. There is a mandamus issued by this court, page number 17, my lord, operative portion. And it has not been obeyed. 8 weeks time had been granted. That has not been complied. Execution of the sale deed.
2nd July.
What is 2nd July? Number 6, Venkatesh Somareddy.
I accept notice for R1.
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 That's complainants are professors who are working in the government science college. They have been absorbed to the Tumkur University. So we had filed a writ petition seeking applicability of old pension scheme, which is allowed, my lords. And there was several directions, my lords.
2nd July. Notice.
R1.
You are for
R1.
R1.
Number 7.
Your Lordship, serial number 7, I appear for
They
a
have
complaint,
complied.
my lord. They have complied the
Already,
order.
already.
Yes, my lord.
Complied with.
both are saying.
Yes, your Lordship, they have complied the order. There was a direction to
Learned
reconsider the issue.
Ms. Leela P. appearing through video conference. It's a statement that the order under contempt is complied with. Most of learned government advocate, Mr. also stated that the authorities are complied with the order.
We have also filed complaints.
Contempt proceedings no more survives, they are accordingly disposed of.
Grateful, my lord.
Number 8, Chandra Tarika K.
I accept notice for R4.
Appear for the complaint, there is a direction to the respondent to hand over the key of the temple. Temple is locked, my lord.
Notice.
You are for R4.
R4.
And
20th,
R1 had
20th.
directed the Tahsildar to hand over the key after the order. Still
When shall
the
we give? 13th of June.
obliged.
13th
Notice is.
Notice order.
Yes.
Please.
Number 9, Ranganath.
My lord, appear for the complainant, my lord. Direction for granting pay scale on par with the others. Direction to be complied within 4 months. They have 2 months. They have not complied, my lord,
For
more than
R1.
2 months.
For R1, I accept notice.
Notice. 1st July.
Number 10, Mr. Vijay Kumar SC.
There's no complaint, contempt, Lord, in this matter. Last may kindly peruse the order.
No mandate.
No mandate.
Number 10, Mr. Vijay Kumar SC.
Page number 14. Para 7. Last 4 lines.
Will not interfere with the possession. There is a direction. It's a constitutional right to property.
If you're interfering with the
Yes.
Let it be sorted. 2nd July.
There's no allegation.
For?
as such.
You are for which respondent?
R2.
R2.
This is number 11.
Yes, I appear, Mr.
Subramania Bhatt.
Mr. Subramania Bhatt, my lord. At page 49, my lord, there was a positive direction to the Commissioner of BBMP to consider my promotion in reliance of judgment rendered in Anil Kumar Sarkar versus Union of India. where my lord, the order to open the seal cover and consider my promotion.
Sealed cover, sealed, 2nd July. Notice.
Seal number 12, Srimati Girija is.
It is for bifurcation of Tamil Nadu. I accept notice for R1.
R1?
Yes.
Notice.
Notices.
3rd July.
Number 13, Satish K.
Therefore, the complainant, but the penalty order was challenged, not was allowed. Directed to pay the amount, but they have paid the portion of the amount, not against the interest, not the corporation preferred an appeal. Appeal was also dismissed, not directed the corporation to pay the interest. Interest is not paid, my lord. As far as other benefits are concerned, my lord, it is paid.
Where is the direction to pay the interest?
Yeah, not page 19 is the order of my lord, learned single judge, but page 19, my lord, last 3 lines. The said sum shall also carry interest at the rate of 8% per annum from 9/4/2012. Thereafter, my lord, writ appeal was preferred, my lord.
Writ appeal was preferred.
Yes,
What happened?
Lord, page 22, my lord, this honorable court dismissed the appeal.
Notice written. 3rd July.
3rd July.
14, Badrinath.
For R2, my lord, to consider the representative.
Consider representation.
Actually, A is page number 10.
R2. G.
3rd July. Notice.
Number 15,
For petition.
Mr. K. Prasanna Shetty.
In this case, the Honorable single judge allowed the writ petition, my lord, with the direction to the government to pay all the consequential benefits arising out of the employment of the petitioner. In fact, my lord, the petitioner was dismissed from service. After the portion, link page number 22 of.
No time limit.
1 year has been lapsed, my lord, because he was.
No time limit. Within 30 days. No, within reasonable time. Notice has to.
3rd July. Notice.
This R5 government, my lord.
R5 state.
Appeal.
Number 16, Mr. Puneet C.
16, I accept notice for R1.
Arrears
to
of
consider.
rent, my lord, of arrears of salary of the year
Not for R1.
2020. Past 4 years, please, my lord, they have not paid the arrears of rent. They had the funds, please, my lord, wide annexure E, page 28. An amount of rupees 8 crores, they had the funds. Despite, please, my lord, they are
3rd July.
Number 17, Mr. Rajkumar MD.
Lordship, the complainant father is denied visitation by the accused mother in contempt of the order passed by the learned single judge, which confirmed the order of the lower court, Your Lordship. The complainant father was granted visitation between 9 a.m. to 11 a.m. every fortnightly, and the same has been denied by the accused mother. Therefore, we are before Your Lordship.
But that affirmed the order of the family court.
Yes, Your Lordship.
Can't you execute that order?
Lordship,
The
it's a-
decree.
Lordship, it's a visitation.
Correct. Decree for visitation rights.
Yes, Your Lordship.
You can execute it.
Very well, Your Lordship. Unfortunately, I was not aware, Your Lordship, that that order could be
We
executed.
have held that way, along with Justice Varale Saab and myself. So held it's a decree for all practical purposes can be enforced as a decree per se.
Very well. The operative portion of the
Wait, you are-
Notice written on 20th June.
28. Your Lordship, may I also be permitted to serve the counsel appearing in the lower court?
No, it's a contempt matter. Under contempt rules, notice have to go by police.
Yes, Your Lordship.
The PL matters, seal number 18, Manjay Gowda, dear.
For non-consideration of representation, my lord, dated 22/9/2023, seeking restrain the street vendors from marketing the vegetables, fruits, and the flowers on the footpath as well as the roadside of the Care Market Road and Avenue Road and the SJP Road
But how can we monitor? You can go before the Upalokayukta, allegation and complaint, both are defined under the 1984 Act. Can we go on seeing whether the vegetable market is stopped or going on, which vegetable is being sold to whom?
My lord,
Can the court monitor these things?
my lord, due to the street vendors, the traffic are jammed. Kindly see the page number, the photograph produced, my lord. The entire, the roads, the traffic, use tropics, and it's a difficult to movement.
Go before the Lokayukta, read Lokayukta Act. It gives the grievance redressal forum for that.
Liberty.
Liberty is Lord Advocate Mr. Sons submits that the petitioner, public interest petitioner would opt to have a recourse to the Cooperative authority, including the Lokayukta, as may be advised in relation to the grievance raised in this petition, reserving such liberty to the petitioner, however, without expressing any opinion on merits of the case of the petitioner, and in respect of such recourse, from the present petition is disposed.
Number 19, Mr. Mohammad Dastagir, party in person.
Your Lordships, this writ petition relates to a notification issued by the state government fixing fares for taxis. Your Lordship finds it at Annexure F. And translation is also available at page number 44 and 45. My only grievance here is, Your Lordships, the fares are fixed based on the cost of the vehicle. They are given 3 different slabs, less than 10 lakhs, 10 lakhs to 15 lakhs, and above exceeding 15 lakhs.
2nd July. Notice.
Lord, the Lord has fixed the date. I'll take notice for all the respondents.
All respondents.
But this actually affects the
All right, we
citizens.
have issued notice.
No, issue notice. My humble request is a earlier date after the vacation may kindly be fixed.
Earlier date is, earlier date is
For any
19th June.
19th June. Obliged.
Number 20, Mr. Sundar Raman.
This is the PIL, my lords, filed regarding closure of 2 railway underpasses in KR Puram, my lords. I arrayed the BBMP and the Railways Department as parties, my lords, because closure and construction and maintenance is within their purview. The difficulty here, my lords, is that this entire neighborhood is locked on 3 sides by the KR Puram railway line, my lords.
We'll file objections, Lord, immediately after vacation.
Notice may be ordered to the other. I'm not pressing interim relief because the demolition has progressed beyond a point.
Lord, for a mandamus, there should be a demand and refusal, my lord. There's nothing, straight away a writ petition is filed.
Last days before vacation, therefore notice.
But 7 meters width of road is available for traffic. We'll file objections.
Because pedestrians are crossing over the railway lines.
Normally, it is not our function, but still let us. Kamath wants to file.
Grateful.
4 and 5 you appear.
My lord, I appear for.
Kamath for 3.
So number 21, Subramania.
For the petitioner. This is a matter where lots 1 acre 38 hectares, which has been earmarked lots and reserved for park in a KEDP layout lots. That has been lots initially refused to be allotted lots in favor of several persons. Later on lots at the influence of lots the local politician lots, it has been allotted to lots the 5th respondent. And subsequently, Milords, it was also suspended, that order. And Milords, now once again, Milords, he files a writ petition before this honorable court, and Milords, that order, Milords, is set aside. However, Milords, the matter is remitted back. Because the KDP officer, Milords, he himself says that it is a Gomar land, it is fit for formation of park. That is, Milords, 1 acre 38 huntas, and there is no revision of Milords, the layout plan. Now, Milords, by taking advantage of Milords, the situation, Lord, they are going ahead with, Lord, the further construction activities. Till now, Lord, it is maintained as path, saplings, Lord, were planted. Lord, I am only, Lord, seeking that, Lord, let them not, Lord, put up any construction. Ultimately, Lord, it will
Let notice.
status quo, Lord,
Lord, I take notice
as
for
on today,
respondent
Lord,
number.
status quo as on today, because, Lord, they are taking the help of the police, Lord, to go ahead with the construction activities.
21st.
Otherwise, Lord, I would not have,
21st
Lord,
June.
press.
21st June. No, no interim. Interim leave is refused. You want that to be recorded.
No, Lord, sir.
First respondent.
Honored the government, additional government advocate. Below for accept notice for.
Respondent number 1.
Lord, sir, respondent number 2, Lord, sir, 2, 3, 4, Lord, sir, PV Chandrasekhar, Lord, who represents the authority, KADB.
It is for you to give no advance copy.
Lord, I
Panel advocates, they may choose whichever advocate they want.
21-6. Seal number 22. The Madhukar.
Your Lordship, I should not interfere in between. In the previous matter, my earlier writ petition is there, WP 3052 of 2020. This has to be tagged along with it.
On that day will.
Oblige.
Seal number
the petitioner,
22.
my lord.
Sumoto writ petition PAL.
This is Sumoto proceedings, my lord. This honorable court passed an order on 8th April 2024 with regard to the non-compliance of the orders passed by the court, my lord. And to evaluate mechanism with respect of compliance of the orders passed by this honorable court.
Lord, I take notice for all the respondents.
Will issue formal notice return of 5th June.
Yes, my lord. And we will also comply with the direction number 9 and 10, my lord, in the order. There is certain direction to the registry. We will comply with that direction also. That is at para number 9 and 10, my lord. Before that day, we will comply with that also.
Supply copy to the learned government.
Yes.
Advocate as well as learned advocate general.
Yes.
Of this petition.
Yes.
So, not.
The respondents also.
Notice to all the respondents.
AG,
Learned advocate for the learned advocate Deshpande shall furnish copy of this petition to learned advocate general as well.
Yes.
For information and intimation to the authorities concerned.
5th June is the date indicated in the order.
5th.
Oblige.
Green bench matters. Seal number 23.
Please.
The
Wait, please.
Register Rajshekar.
My lords, the demand noticed by R2, my lords, that he has not lifted the sufficient quantity of sand despite the sand. For having not lifted the sufficient quantity of sand, my lords, the reason he has given the explanation, reason he has assigned is that they did not form the roadway, they did not allow him to.
Not a revisable order. It is 53.
53.
Rule 53.
Yes.
Yeah, well done.
And similar case, my lords.
Similar case we have said,
Please.
except in 2 exceptional cases which fell into 67 Supreme Court. We have said you have to avail the revisional remedy. It's a very widely phrased provision.
I brought on, only one sentence may be permitted to submit, my lord. Annexure J and similar circumstances for others for not lifting, they say we give. It's for not lifting the sufficient quantity of sand. In other cases, identical case, my lord, annexure J, they give exemption.
File revision application. The rule 53.
Yes.
Of
KMCR.
Till the
revision there, my lord, is considered, your lordship may kindly protect us from any coercive action. They have power to grant interim relief also. They have held in two matters like. Please, till they consider it, my lord, now that the demand notice has come. Said that we have to make.
What is challenged is a demand notice.
That's what. Demand notice.
Where is the impugned order?
Notice.
Annexure G.
Annexure G 27.
29, page number 20.
The alleged lapse here is that I have not lifted sufficient quantity. That is the allegation. No other contravention, my lords. Why I couldn't is, of course, I do concede, my lords, my lords view that about that alternative remedy. And that only for not meeting this sufficient limit of lifting, my lords, they impose this. But in identical case, they exempt him, my lords, on the very same grounds. Page 48. Similar grounds were urged in another case, my lords. As far as he was exempted up to 50% for the upper limit. That's in annexure J.
In course of the hearing, sorry.
Please.
When a query was put to learned advocate, they're withdrawing or we pass the order?
Shall we pass the order or you want to withdraw? Your lords may kindly grant me liberty to go before revisional authority.
Learned
Please.
advocate so and so, seeks permission to withdraw the petition. Accepting the position of law that the order impugned in this order of endorsement impugned in this petition is amenable to revision under Rule 53 of the
Karnataka minor mineral
Karnataka minor mineral concession
concession
rules.
1994.
1994.
To state further that the petitioner would opt to avail the said recourse. So permission is granted to avail such remedy of revision.
May only.
This court, however, has not gone into the merits of the case of the petitioner, nor has expressed any opinion on the merits.
Grant me time to approve so that the period of limitation.
90 days, no? Revision is 90 days.
Yeah, because this
Still
is
time
9th February 2023. Order is
90 days will be over when? It's only in
23. Order is 23, my lord. Therefore,
If the question of limitation arises before the revision authority, the time spent for filing and prosecuting this petition shall be treated as bona fide consumption of time.
Please.
To be taken account to that extent by the revision authority.
Number 24.
Section 14 of limitation. Given that we came within time before this on the court, not before the.
Therefore, that period is
Therefore,
now.
this-
That's it.
24.
14.
Shivkumar Devi.
Paper for the petitioner in this case, please. Petitioner, my lord, is challenging the order passed by the Director, Department of Mines and Geology, my lord.
Revisable order. Revisable.
Revisable order, but it is covered by the
Judgment against the petitioner.
Because it's not a saved application. In view
Similar
of-
matters we have treated already.
My lord, in this case, my lord,
There are
no opportunity of being heard is given, my lord. Therefore, my lord, let the Director, Department of Mines and Geology hear the matter, my lord. I will file my all statement about sections.
There are 3 more judgments following
Yes.
this judgment.
And the rejection is of the year 2019. Rejection is of the year 2019. There is delay also.
Even on merits, there is that.
Yes, sir.
Rule position we have clarified. Dismissed.
My lord, go through with this, my lord.
There is nothing more for that of your stature. In minutes you will catch the position of law we have stated. We may take more time. You are from the mining law domain. That's nothing. Dismissed.
Please. Oh, please.
Number 25. Ravindra Gajanand Kolle.
Please, my lords. In an identical matter, my lords were pleased to issue notice to the other side
No, it is, I think it was dismissed on identical matter we
that-
covered
that-
Yes.
with that judgment.
Yes, my lord, I'm ready.
That is with reference to rule 8B, my lords, but I am not
About
on.
Identical matter. Kindly see, look into that judgment. We don't have any other job. We compile our judgment so that we can use the pattern for disposal of matters.
I may be given some time to.
Your
go through
lordship's
and-
order is also there, that is not uploaded, my lord, and that's why I'm 8A8. It's a rejected application.
So 8A8 is not at all applicable.
We have considered this argument also.
8A8 is not applicable, but anyway, I will go through and I may be given a short time, my lords. Maybe
There is nothing.
taken up next week, I mean, this weekend.
There is nothing. Nothing covered by judgment.
Squarely
Squarely
I
covered by
cannot be
judgment. We
taken by
cannot go
surprise.
on.
Either let them file statement of objection.
They need not file. Why?
Because, my lords, my entire rights.
They know whether to, can you compel the defendant to file the WS? Here is a matter which is squarely, otherwise we will never say. Twice we think before negativing the relief to the litigant.
But
we will not do it.
No,
But
I will
we
be
cannot go on.
greatly prejudiced, my lords.
You'll not be
If
prejudiced.
I am not given an opportunity of at least going to judgment, he could have given me a little earlier.
He did not know that we would be filing a petition.
And my only submission is I am not asking, tomorrow it may be placed, my lords. This is almost denying the principles of natural justice, my lords. Please, my lords.
Date.
Yes. Some date is after occasion.
Please, my lords.
10th of.
10th of June. Twenty-six urgent, seal number 27, Mr. Prakash BS.
And it's covered by the
Covered by judgment.
deemed conversion. Only
Time-bound manner they have to dispose of.
What we did in other matter, identical matter, we did
It is
myself and
produced.
Varales. Has it produced it?
Yes, yes. Page number 20, annexure D. Order is at annexure 20, page number 29. Krishna. Only one word has to be added because if the representation is not decided yet.
As it. Same.
Please, same terms.
Same terms.
Page number 29 for 29.
Seal number 28. the Ganpati
This
Bhatt.
case, my lord, I am for the petitioner. This is, my lord, the National Highway Project, my lord, under Prime Minister Bharat Mala. The crusher license has been granted and 2 quarry lease has been granted to the petitioner for construction of Hirur to, my lord, the Kotagere. And accordingly, my lord, kindly see annexure C in page number 40. My crusher license insofar as survey number 50 measuring 9 acre 36 guntas has been extended up to, my lord, October 2024. And, my lord, kindly see annexure C is the license which is extended up to, my lord, 2024. My lord, your lordship will get annexure C translated copy. Now, my lord, insofar as, my lord, the crusher license 594 and in the 595, is concerned, my lord, that I have approached, the earlier notice was issued. Thereafterwards, my lord, that I have approached this honorable court. This honorable court was pleased to direct it to approach revisional authority. Insofar as query lease is concerned, kindly see inquiry number 60, my lord. 2 writ petitions are pending consideration before this court. Kindly see annexure, my lord, F60.
It's a revisable order.
No, here, my lord, I will submit, my lord. Insofar as, my lord, the revision order already passed. Subsequent to that, my lord, they have nullified revisional order. That is, I have placed. Therefore, my lord, I want to see in page number 60 annexure F. I have challenged revisional order. Revision order in page number 88 may kindly be seen. That is pending consideration before your lordship. For a moment. That is, my lord, revision 65 of 2022-23. I have this writ petition pending. Kindly see, during the pendency of that petition,
This is still pending. Annexure F is still
yes,
pending.
still pending. Till, no, I'll please, I will complete, please, I request. Kindly see, this writ petition, therefore I have produced, I have this writ petition is pending. Kindly see next page in page number 92. This is, my lord, QL number 595. Here, my lord, writ petition also QL number 595. Insofar as 595 is concerned, during the pendency of this writ petition, revisional order, they have, my lord, conducted drone survey and reduced of 20 crores to, my lord, 6 crores 25 lakhs. Kindly see in page number 98. This is dated 5/4/2024. Date is very important. And insofar as another writ petition is concerned, my lord, they have nullified. They have demanded 12 crores and they have said 0. Insofar as, my lord, another 594 is concerned. Next 114, my lord, kindly see annexure H. Operative portion of the demand notice is, my lord, 120. They have said, my lord, you need not pay. Insofar as 594 is concerned. 120, my lord. They have said, my lord, ಕಲ್ಲು ಗಣಿಗಾರಿಕೆ ಮೇಲ್ಕಡೆ ಹೊರತುಪಡಿಸಿ ಯಾವುದೇ ಉಪಖನಿಜ ಪ್ರಮಾಣ ಪಾವತಿಸಿದ ರಾಜ್ಯಧನದ ವ್ಯತ್ಯಾಸವಿದ್ದ ನೋಟಿಸ್ ತಲುಪಿದ ಸೊ ಇದರಲ್ಲಿ ಕೊಡಬೇಕಾಗಿಲ್ಲ ಅಂತ ರಿಟ್ ಪಿಟಿಷನ್ ಇನ್ಫ್ಲೆಕ್ಚಸ್ ಆಯ್ತು ದಟ್ ಐ ವಿಲ್ ಮೇಕ್ ಸಪರೇಟ್ ಸಬ್ಮಿಷನ್. Insofar as another tool, please.
We have one submission to you.
Please.
These are special matters, complex matters, which generally judges would not entertain. That is the reason why revisional remedy is provided under the governmental system.
Yes.
Because they will be knowing the things.
Please. Since, my lord, that already revision approached and during the pendency of writ petition, kindly for a moment, my lord, kindly I'll seek, my lord, your lordship's attention to pendency of writ petition in page number 89, 88, once notes. I can understand, my lord, your lordship, since, my lord, that I have challenged, my lord. I am not saying. And pertaining to not this, no, my lord, on the same day, 5/4/2000, I am challenged before this honorable court is annexure J. Notice for stopping the crusher unit, my lord, which is extended.
In 88,
please.
What you have challenged
Yes.
is the order passed in revision.
That is what, the same subject.
88.
Yes, this is same 595. Kindly see, this is QL for 595. I'll see same 595, my lord.
So it's not a revised order. Kindly come to page 88.
Please.
But please come to page 88.
Please, I may permit.
Read now. Read your prayer.
Issue writ of certiorari appropriate order quashing the impugned order revisional petition so
In
and so
revision
65.
petition, so and so.
Yes.
Now show that this order is made in revision jurisdiction. The one which you have now laid challenge to is not in revisional jurisdiction.
No, I'm bringing your lordship's note. This is not,
You have seen,
I'm bringing.
All special matters, why judges should not, see that Chandra Kumar,
No,
L. Chandra Kumar.
no,
versus Sweeney
no,
and all.
I am bringing your lordship. Kindly annex J, this is crusher. I am, since, my lord, E case pending is there, suspension order ಕೊಟ್ಟಿದ್ದಾರೆ. Annexure J may kindly sing for a moment. I am challenged, kindly see Annexure J. Annexure J is nothing to do with, I am bringing your lordship's notice. For a
All that
moment,
you can-
one minute.
All that you can complain to the revisional authority. The wording of that provision, rule 53, is as wide as appeal itself.
My lord,
Although
I beg
it
to,
uses the word reasonable.
I beg to submit I am challenging Annexure J, not this. Because idralli ದುಡ್ಡು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಮ್ಮ crusher unit. I am not challenging this before this court. That is different. Kindly Annexure J, one ನಿಮಿಷ ನೋಡ್ಬಿಟ್ರೆ I am begging. Kindly see, my lord, Annexure J. This is, my lord, crusher unit, which is scheduled property. This is, I am challenging Annexure J. This, my lord, has, since, my lord, that two, they have raised demand in 594-95. ನೀವು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ crusher stock ಇರೋದನ್ನ kindly for a moment see, my lord, the inquiry number 139 may kindly visit. 50 ಲಕ್ಷದ this is a stocked metric ton for formation of highway.
Without obtaining MDP during night time, in the absence of officials, you have transported is the version.
No, stop.
Kindly see that. Kindly see that.
So kindly see, my lord, this is.
Challenge, write down.
I have
challenge.
paid.
Sorry, counsel. Challenge in this writ petition.
I am extremely sorry. I am regret, my lord, for this. I am regretting. I am sorry to say, this is the order, which is not, my lord, this is pendency of writ petition. I am bringing your lordship. I should not suppress. Therefore, I have challenged this. I have produced that. Not that. This is, my lord, first time issued on 5-4 violation of absolute natural justice. When there is a stock, this is national highway, national important project. Not that I am not paying. Since they have issued notice to the quarry license, they can't, these two separate enactment. Therefore, I am seeking to stay. I'll deposit amount.
We are not inclined to entertain in view of the availability of the remedy.
No, this is not revision. Since, my lord, this is not 53. This is crusher license.
Let us see.
This is crusher license. I am challenging. Annexure 15 years I have to go. This is, my lord, suspension. This is crusher license. That 53 is KMMRC rules. I am extremely sorry to make submission. That, my lord, that is rule 15 that I have to go. If it is, my lord, this is crusher license, which is, my lord, stopped by virtue of pendency of, my lord, KMMRC rules notice. Same day.
Fairly false within the parameters of rule 53.
Rule 15, my lord, a regional authority, I have to go.
Any person
That is crusher license.
of the competent authority, not above the rank of additional director of within the services.
90.
So any
That
order, any person.
Rule 15 of crusher Stone Crusher Act. This is, I have to approach. Section 15 of Stone
Under 53, not 15 of.
No,
the
I am
crusher
not
act.
asking, this is crusher stoppage.
Correct.
Crusher
But
license.
order is relatable to the one which would fit into 53 terminology.
No. This is rule 15 of Stone Crusher Act.
15 of?
Stone Crusher Act.
Appeal.
Appeal
under
provision.
section.
1.5. Therefore, my respectful submission, I am ready to deposit. Since, my lord, on same day, 5/4/2024, they have, since ಅಲ್ಲಿ demand ಮಾಡಿದೀವಿ ಅಂತ ಇಲ್ಲಿ stop ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ I am requesting. I am ready to deposit 1 crore, 2 crore before this court. Because National Highway project, 1 ತಿಂಗಳ ನಿಂತು ಬಿಡುತ್ತೆ. That is what my humble request.
Mr. But just we want to have clarification.
Please.
See the designation of the officer who has passed the
He is
order.
the member secretary of Stone Crusher. This
Very same authority.
Same authority.
Then appeal lies.
Appeal, section 15, I am saying,
Correct.
provided, ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ National Highway project, special provision. Therefore, my respectful submission in other question. KMMRC rules are notice issue ಮಾಡಿದ್ರು. We have approached revisional authority. Revisional authority passed order, which is challenged before this honorable court. During the pendency of writ petition, they have issued another notice. That writ petition, my lord, that I am producing that. Now, ಆ petition ನಲ್ಲಿ ನೀವು ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ಇದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದೆ. That's all my request.
It in substance fits into 53, not 15. It speaks of MDP, etc., which are the building blocks of the concerned provisions of the 94 rules.
Kindly for a moment. This is, my lord.
So according to you.
For a moment, Vishek Bandhu.
Please answer before proceeding.
Yes.
Please answer before proceeding.
Please.
Yes. You have to attend to the queries of the court straight away.
My respectful, yes, I'm sorry.
No debate. Please answer the query.
Please.
According to you, it is rule 53 applies or
50.
Section 15 applies?
15. Stone Crusher Act.
Now proceed.
Stone Crusher Act.
Now proceed. So 15, rule 15 appeal is available according to you.
Yes.
Now proceed.
Kindly see, my lord, insofar as, my lord, this notice is concerned, they have, my lord, on 5/4.
You can't go on avoiding query of the court like this. We don't approve the conduct of the submission, the way of you are submitting.
Then,
You
my
can
lord,
argue at any length.
I leave it because, my lord,
No,
this
Mr.
is
Counsel.
national, therefore, my lord, I'm sorry. I will not make
It is-
any submission
It
further
is not
because,
by,
my
a-
lord,
it is not by of comment or complaint.
no,
But-
I humbly request because it should
Any-
not get just, therefore, my lord, I'm not,
Any length of time you may consume your
I-
argument,
I-
but please answer the query of the court.
Please.
That is the only-
this is 15, kindly for a moment. On 5/4/2024, Annexure J has been issued saying that they have demanded money for quarry license. That is 594 and 595. Whereas they have said 6 crore 25 lakhs pending. Therefore, my lord, you have to stop till payment of that. This is the notice. My respectful submission is, there are 2 writ petition pending before this court. During the pendency of writ petition, they have conducted survey, and my writ petition nullified and 1 writ petition become infractious. They have said you are not paying. Only 590 QL of 595 concern, my lord, 6 crore 25 lakhs demanded. Whether I am going 53 or before this court by amending is different issue. My respectful submission is, insofar as demanded amount is concerned, not quarry crusher license, there is a stock of 50,000 metric ton which MDP has been paid as per page 139. And, my lord, that is stock. And there are 500 workers are, my lord, is there. If this road construction work by virtue of the stop, all of them have to stop because the 1 month holiday. Therefore, my lord, I am begging your lordship, any, my lord, towards hurt, my lord, that I have not made, provided I want to convince, kindly 139 page may kindly be seen. This is, my lord, MDP paid, translated 145. Translated copy. I'm sorry, 145.
But is not in good mood today.
Sorry, because, my lord, National Highway project, 1 ತಿಂಗಳ ನಿಂತು ಹೋಗುತ್ತೆ, 500 ಜನ ಕೆಲಸ. This is, my lord, 145 translated copy. Quantity stored in metric tons, 50,65,027 metric ton, my lord, has been stored for formation of road.
Please come to 139 now.
Please.
Since you are insisting,
Please,
I will make you to read in the colloquial language.
please.
ಆದರೆ ನಿಯಮ 7 ಅಡಿಯಲ್ಲಿ ನೀಡಲಾದ ಕ್ರಷರ್ ಲೈಸೆನ್ಸ್ನ ಅವಧಿಯು ದಿನಾಂಕ 28/2/23 ಮುಕ್ತಾಯಗೊಂಡಿದ್ದು.
House.
Because translation is, we are not happy with the translation.
Yes.
Therefore, we are reading
Please,
it out
please.
now.
Sadri,
MDP ಮೇಲ್ಕಂಡ ಕ್ರಷರ್ ಘಟಕದಲ್ಲಿನ ಉಪಖನಿಜಗಳನ್ನು ಸಾಗಾಣಿಕೆ ಮಾಡಲು MDP ಅವಶ್ಯವಾಗಿರುತ್ತದೆ. ತಾವು MDPಯನ್ನು ಪಡೆಯದೆ ಸಾಗಾಣಿಕೆ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರುಗಳು ಬಂದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಕಚೇರಿಯಿಂದ ತಂಡಗಳನ್ನು ರಚಿಸಿ ಪರಿಶೀಲನೆಯನ್ನು ನಡೆಸುತ್ತಿದ್ದು, ಆದಾಗ್ಯೂ ಹಗಲು ಮತ್ತು ರಾತ್ರಿ ವೇಳೆಯಲ್ಲಿ ಕಚೇರಿಯ ತಂಡದ ಅಧಿಕಾರಿಗಳು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಸಾಗಾಣಿಕೆ ಮಾಡುತ್ತಿರುವುದಾಗಿ ಹಾಗೂ ಚಿತ್ರದುರ್ಗ ಮತ್ತು ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ವ್ಯಾಪ್ತಿಯಲ್ಲಿನ ಕ್ರಷರ್ಗಳಿಂದ ಪರವಾನಗಿ ಪಡೆದು ಸದರ್ ಡಾಂಬರ್ ಪ್ಲಾಂಟ್ಗೆ ಸಾಗಾಣಿಕೆ ಮಾಡಿಕೊಂಡು ನಂತರ ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ದಾಸ್ತಾನನ್ನು ಬಳಸಿಕೊಂಡು ಯೂಸಿಂಗ್ ದ ಸ್ಟಾಕ್ಸ್ ಇತರೆ ಕ್ರಷರ್ಗಳಿಂದ ಪಡೆದ ಉಪಖನಿಜ ಪ್ರಮಾಣಕ್ಕಿಂತ ಹೆಚ್ಚುವರಿಯಾಗಿ ಸಾಗಾಣಿಕೆ ಮಾಡುತ್ತಿದ್ದಾರೆಂದು ಆಗಿಂದಾಗ್ಗೆ ಕಚೇರಿ ದೂರುಗಳು ಬರುತ್ತಿರುತ್ತವೆ. This is how it is structured.
reference number 7. The reference number 7, my lord, is, my lord, I have produced, that is 1595. ಅದು crusher license ಬಂದಿದ್ದು ಅಂತ.
Even otherwise, according to you,
Please.
if it is not revision, according to you,
Appeal.
it is an appeal.
Appeal.
Whichever alternate remedy you can avail, which you can avail. Why we should spend so much time on this matter itself? These are all special, the object, read 69 Supreme Court, Dulabai versus State of MP, the Constitution bench judgment which Justice Hidayatullah has scripted. Why we should not, and see that L. Chandra Kumar versus Union
Lord,
of India.
I'm fully agree with, I'm as a member of the bar, I'm making submission before this honorable court. This honorable court time and then considered, my lord, revisional authority, I'm making a member of the bar before this court. Revisional authority, if your lordship sending, that is another opportunity to make money. I'm making submission, file affidavit, because minimum 10 lakhs is required. I'm making submission, this, and no order will come. No order will come. I'll establish by posting 10 writ petitions which I have produced. And all revisional, sorry.
We cannot say much on that, but we understand what everybody in the
yes.
bar knows, what is happening, Mr. Mahendra. Unless such submissions are made, vociferously by a tall advocate, by Mr. Bhatt, because they have that experience. It's not that he's painting everybody, but court can take presumptive.
Particularly not.
Your
in
extraneous
default.
submission will not persuade us to say that remedy is available.
Please, please,
So what do you want? Are you inviting order or withdrawing to approach the,
your lordship can pass out.
your choice? Mr.
My lord, insofar as, my lord, my respectful submission.
So we are
is,
giving you the
I
option.
can, my respectful one submission, I can deposit whatever demand. And if at all I am liable to pay in KMMRC rules, that amount can be adjusted because 5,500 workers and road formation. I am deposit amount 2 crores, I will deposit a front before this court. If I am liable to pay, I will pay. This
Now
thing.
only 2 options are there.
Please, please,
Then option starts now.
please.
Whether you are withdrawing to approach the alternative, avail the alternate remedy, or you want to invite our order. That is the only thing.
Withdrawing.
Between learned counsel for the petitioner seeks permission to withdraw the present petition, stating that the petitioner would opt to avail the alternative statutory remedy.
I'm extremely sorry for making
Granted,
submission,
the-
not.
But the petition is disposed of as withdrawn, reserving liberty for the petitioner to avail the remedy under the law. This court, however, has not gone into the merits of the case of the petitioner, nor expresses any opinion on the merits, including the recourse which may be undertaken by the petitioner, disposed of accordingly.
My lord, one submission, I'll list, my lord, 2009 revision petition disposed of in 2023. I have also filed, there are several petitions I'll list after vacation. To you, bring your lordship's notice, the fate of revision. Please.
Twenty-nine urgent, seal number 30. Mr. Prasanna VR.
Yes.
29 urgent.
Urgent. Date, my kindly.
Date is given, your friend took time.
Please.
My lord, serial number 30. My lord, yes, my
Continue.
lord. Yes, my lord. It's adjourned to 18/6.
When it is kept.
18/6, my lord, along with connected matters. My lord, there is an interim order also that has been granted.
Status quo we have ordered. In all matters,
In all
status
matters,
quo
it
we
is-
have ordered.
My lord, in some
Notice.
matters, my lord has granted,
Day and in other matters,
yes.
status.
Status
Yes,
was
yes.
granted. Notice
Please.
18th of June.
Please.
To be listed as 64 same. Delay is there, so then only notice,
Please, no, please,
18th.
please.
obliged. My lord, I take notice for respondents 1, 2, 3, my lord.
You're for 1 to 3.
1, 2, 3.
Number 31. Pradeep S. Sarkar.
I appear for the appellants in this case. Not there is.
Also.
You order the learned single judge, whereby, my lord, the learned single judge has granted promotion automatically, even though the petitioner is not, the respondent is not entitled to promotion. It was rejected twice in 2013 and 17.
There cannot be direction to grant.
My lord, and the funny part is,
Did that.
yes,
That is a part, but promotion.
yes. In fact, my lord, he has been granted promotion when he was eligible and he was selected in 2019. Now, my lord, learned single judge says, with effect from 1/4/2013. Now, my lord, he retired in 2021, comes before your lordships after retirement, questioning the rejection of promotion in 2013 and 17. My lords are aware.
My lord, if he has a grievance regarding promotion, the maximum time is 1 year, not beyond 1 year. Yes. Lord,
Lord, my lord,
serial
I have
number.
responded here. I am responded here, my lord. I already filed a contempt petition. Contempt petition serial number 46 is there.
Serial number
They
46.
not served
the
copy
contempt
also, my
petition
lord.
May be taken up along with this, my lord, contempt petition.
They have to submit copy, my lord. I am the respondent, my lord. They are not submit the copy.
Consider direct promotion, not
They
employee.
have to serve copy, my lord.
Have you filed
Acceptable
caveat in this
copy.
matter? Caveat is filed.
What?
Caveat, have you filed caveat? Caveat
Already,
ಹಾಕಿದ್ರಾ?
I already filed caveat. They willfully they waited for 90 days to be lapsed.
No, that
After
is there.
lapsing 91 days, they have 61 days contempt delay is there.
Caveat lapses after 90 days, the scheme of law.
That is
You
okay, my
can't
lord.
file
I
it.
will ask them to serve copy, my lord. I will go and file objections. Sir.
I'll serve a copy. I'll serve.
Date I want, but date, my lord. Date, I want date.
Any. First.
First. Okay. Combine the case, my lord.
Obliged. There is a delay, my lord, 61 days. 61 days of delay.
61 days delayed, master. It is not a administration delay, my lord. It is willful delay, my lord.
Just 61.
Pradeep Savkar.
%, Ramakrishna.
May.
Very.
Sir.
I will provide the copies. Yes.
Thank you, ma'am.
Lord, serial number 46 may kindly be called along with this, Lord, is filed a contempt petition.
40.
46.
46.
Yes.
So far, they are not complained, master.
Obliged.
Respond. See that.
Number 32. To Nityananda Naik.
Appellant challenged the orders passed of the Honorable Single Judge in writ petition number 1187 of 2023.
Yes.
32.
Appellant is challenging the orders of the Honorable Single Judge in writ petition number 1187 of 2023 at page number 24 to 27. There is a delay of 19 days in preparing this appeal. Because of delay in approaching the revenue authorities.
1932.
Lord, because knowledge, the petition got knowledge only when he applied for obtained the revenue sketch in 2021. Then only you know that there is a wrong mentioning of survey numbers. The date of knowledge.
19. You can't say that Alexander, we did not know Alexander had come to India in BC 323. You can't
No,
say
their
that.
agriculture is.
We live in a reasonable society with assumptions that you will be knowing things. 1932, how can we? Learned judge just rightly done that.
Not given a speaking order by learned judge, only dismissed summarily on based on the endorsement given by the respondent number 2, my lord.
Dismissed.
Say number 35. The Tejas SR.
Not appear on behalf of the. My lord, admitted positions are these, that I have paid the entire amount of 6 crores and odd for allotment in the land from KADB. And we have been put in possession. That, and now, my lord, on the allegation that the property has not been used within the time prescribed, my lord, action is sought to be taken to dispossess me and cancel the allotment. That is what is called in question before the learned single judge. The grievance made, my lord, was, apart from facts, that Section 34B of the Karnataka Industrial Areas Development Act has not been followed, and that is an admitted position. Learned single judge, my lord, contrary to, if I may say so, to the pleading of the respondent, holds that possession has not been given to me. My lord, please be kind enough to see that finding recorded by the learned single judge, my lord. If your lordship will kindly see the finding, my lord, at page 49 and 64 of the order of the learned single judge. My lord, may I trouble your lordship to kindly see the bottom of page 49. The aforesaid clauses indicated that civil work should be completed within 24 months from the date of taking possession of the scheduled property. Therefore, physical possession of the property was yet to be taken. And on that basis, kindly turn to page 64 on the top. In the light of the judgment rendered by this court, there's an earlier judgment, my lord, which the same learned single judge had rendered. In the light of the judgment rendered by this court interpreting section 34B, wherein it is clearly held that it would kick in only in cases where physical possession is handed over by the board to the allotee and not prior to it, physical possession would admittedly be handed over only after execution of this come sale agreement, which circumstances yet to come out in the case on hand. Now, my lord, please be kind enough to turn to page 179. Para 8, the statement of objections filed by the Karnataka Industrial Development Board before the learned single judge.
Allotment is of which year?
My lord, the allotment was made, my lord, in 2013.
12/8/2014.
12/8/2014.
15 to 2013. Let me give the facts if you don't mind. 15 to 2013, my lord, is the date on which allotment was made. Confirmatory letter of allotment was issued on 12/8/2014. By which time, my lord, the entire payment of 6.30 crores has been paid. And this is a bank, my lord.
And subject to condition that you will do certain things.
Yes. My lord, what happened was the confirmatory letter of allotment and the letter of allotment did indicate that. But then, my lord, what happened was we were given possession of the property on 27/12/2014.
2005, before 12/8/2014.
My lord, no, my lord, 27/12.
27/12.
These are all admitted positions. And then, my lord, time schedule was given. And then, my lord, what happened was the draft of a lease cum sale agreement was sent to us.
On 23/3/2016.
Yes, my lord. And on 8/1/2015, in fact, they didn't even send it. We requested them to send it to us on 8/1/2015.
When the lease was given to you, lease deed was executed.
But not executed.
Not executed.
No,
Lease
lease
deed
cum
is not
sale agreement has
executed.
not been executed. That is the question, my lord. Whether 34B applies.
in a situation only where a lease cum sale agreement is executed or not. And the learned single judge says you have not been put in possession, which is the wrong finding on fact. My lord, if your lordships are kind enough to see, give me.
Now, assuming that you are put in possession.
Yes. Now
Still
34B applies.
Is a lease is
34B applies. And learned single judge says that you have not been put in possession and proceeds on that basis. Please see, my lord, page 179 of the statement of objections filed by KIDB before the.
No,
learned single
admitted
judge.
position is lease is not at.
No.
No lease
cum sale
deed
not
is given.
Not executed.
He wants change in the terms and condition of the lease deed for, my lords, he wants specific condition for him.
But that question, my lord, in law.
That the question is answered by one of.
My lord, in fact, my lord, there is, I'm sorry, 34 capital B.
Possession is with you.
Possession is with me, admittedly, even under page 179 of the statement of objections. And the finding recorded is contrary.
There is, kindly read section 34B.
Please, my lord, I'll just, the 34B applies only if a lease cum sale is executed.
Correct.
Assuming he refuses to execute the lease cum sale deed, so invocation of 34B does not arise. Only after, if we execute a lease cum sale deed, we follow the procedure under 34B. Prior to 34B, we will not, his cases, you follow 34.
Which is the section which gives that power to you?
My lord, 34B, can I read 34B, my lord?
Read 34B.
Resumption of possession of premises.
The heading also, because in India, headings are voted in the parliament, in the legislature,
reading
unlike in England.
I'm reading the heading.
Yes.
I'm reading the resumption of possession of premises, including residential tenements, on breach of terms and conditions of the lease or holding without authority. So therefore, where the board is of the opinion that an allottee of any premises or part thereof or residential tenement is an industrial area or industrial area has violated any of the terms or conditions of allotment or holds it without any authority in any way, without prejudice under section 20, give notice to the allottee and the bank or financial institution in whose favor the board has permitted the mortgage or lease rights of the premises or resident tenement, specifying the breach of the terms and conditions of the allotment, calling upon the allottee to remedy the breach within the time specified in the notice. Subclause 2. If the allottee fails to remedy the breach within the time so stipulated, the board shall serve a notice upon the allottee under intimation of such banks or financial institutions to show cause within 30 days from the date of the service of notice why possession of the premises or part thereof the residential tenement should not be resumed. Then after considering the cause, if any shown by the allottee and after giving him an opportunity of being heard, the board may pass such orders as it deems fits. Where the board passes an order under subsection 3 for resuming possession of the premises or part thereof or residential tenement in the industrial area, it may by notice in writing or order any allottee to surrender and deliver possession thereof to the board or any person duly authorized in this behalf within the date specified in the notice. If the allottee refuses to surrender or deliver the possession of the premises or part thereof or residential tenement within the time specified in the notice, the board or any officer authorized by it in its behalf may resume the possession of the premises or part thereof or residential tenement free from all encumbrance and for that purpose may use force as may be necessary. This question would arise 34B. If I had executed a lease deed, he violated any terms and condition of the lease deed, then I should follow the procedure of issuing notice, hearing them, passing an order. If he does not, after passing an order, if he doesn't give possession, I can resume possession. Here is the case, only an allotment, admittedly as allotment is given, possession is given. He refuses to execute the sale deed, saying that read, draft the terms and conditions of the lease deed. He replies saying these clauses should be changed. We said it cannot be changed. We have been format of the, and one more thing, he says Kannada, he will not give employment as per the terms and conditions, not throughout all the thing, one Kannadiga should be given employment. He refuses to give employment, then remove that condition also. Throughout it has been given, Malots. Draft format is there for all the industries. Everybody has accepted these terms and conditions, except the appellant.
So you want to change in some conditions?
No, my lord. I
Yes,
tell you, lordships,
page
no.
44. That is, I'm sorry, my apologies. My apologies. My apologies.
But what happened, my lord? There is a stipulation. If your lordship will kindly turn, my lord, to page. If your lordships will kindly see, my lord, page 139. Now, this is a bank which operates all across the country. The allottee, my lord, who is appellant before your lordship, is a bank.
139.
139.
My lord?
139.
Yes, my lord, page 139. Yes, my lord. Kindly see, what was in grievance was class 20A. The learned single judge mistakes it to be class 20B. That is the problem. In fact,
20 capital A.
20A, small a.
Employment to Kannadigas.
Yes, my lord. All that we said was, my lord, kindly let me give you a lordship. My lord, my lord, even though the allotment was made in 2013, they never gave us a draft of his lease deed.
No, that's all right.
Yes.
But 20A.
20A says.
Because you are taking land of the state.
Yes.
Therefore, native people should be favored is the policy.
I understand. We said we will endeavor to do it. Please don't make it a condition of the lease.
No, it cannot be. See, ಇದು ನಮ್ಮ ಕನ್ನಡದ ಲ್ಯಾಂಡ್ ಇಲ್ಲಿ ಲ್ಯಾಂಡ್ ಎಲ್ಲ ತಗೊಂಡು ಹರಿನವರಿಗೆಲ್ಲ ಕೊಟ್ರೆ ಮುಂದೆ ಕನ್ನಡಿಗರು ಏನ್ ಮಾಡ್ಬೇಕು ಸ್ವಲ್ಪ kindly have this. The objective very laudable because you are taking the land of the state.
Please look at it another way. Here is a bank which is operating all across the country. Wants to set up a mega computer center to control the operations all across the country. If you don't mind. No, if you want to make a submission,
What he says, ಅಲ್ಲಿ ಕನ್ನಡಿಗರು ಅನಾಥರಾಗಬಾರದು ಅನ್ನುವಂತ ವಾಯ್ಸ್ ಇದೆ ಅವರಲ್ಲಿ.
Land is there.
ಕರ್ನಾಟಕದ ಲ್ಯಾಂಡ್ ಅದು. ಕನ್ನಡಿಗರು ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ನಾವು ಉಳಿಸೋದೇನು ಕನ್ನಡ?
I understand all the emotions, my lord. I fully participate in the emotions. But the question, my lord, is
law has enacted emotion.
That is not the question, my lord. The question is slightly different, if I may. We are not on the question as to whether 20A is followed, not followed. The question, my lord, is as to whether 34B of the KDB Act presupposes that there should be a lease cum sale agreement. I tell you, lordships, why I am raising this point at the outset. There is a division bench judgment of the High Court, which says that the relationship of landlord and tenant or a lessor lessee is created even without execution of the lease cum sale agreement. And we pointed out to that the division bench. Kindly see the judgment, my lord. Please be kind enough to see the judgment of 2001 SCC on inquiry. This is the judgment which operates today. I'll read your lordships. In fact, I stand on a better footing now. And learned single judge, my lord, relies upon the judgment in Kamalaraya case where possession not given, payment not made, and then say, therefore, 34B won't apply. I agree there. But I am on a different footing.
But lease is defined to my
Well,
memory.
kindly see what
I
division bench has said.
In fact, we look into.
Yes.
To my memory.
Yes.
The lease is defined under the Transfer of Property Act.
Yes.
One of the essentials of lease is delivery of possession.
Admitted.
That possession is admitted.
My lord, kindly see page 179. My lord,
Possession is admitted.
Possession letter has been given, my lord.
No, my lord, let us.
I'm conceding, so that I'm not in his favor itself, I'm not saying anything again, so that your lordship need not turn the page.
My lord, the finding recorded by the learned single judge that possession has not been given is contrary to the stand taken by the KIDB. And now, my lord, in that context, may I trouble your lordship to kindly see the division bench.
Still you want to say, though possession is given, that is one of the components of the definition of lease. The creation of interest is a must under that, which is that section.
34B itself.
Lease
Transfer
is-
of 106.
Transfer of property.
106.
106.
But kindly see the division bench judgment of this court under the KIDB Act in an appeal filed by KIDB.
Which is that?
My lord, if your lordships are kind enough to turn to 2001 SCC online, Karnataka 839.
The act. Section 5. possession and enjoyment. Against you. Transfer of property.
My lord, may I?
I look it.
Yes.
We look it.
Please be kind enough to see section 105, my lord.
You were not aware about these stipulations in the proposed sale, these days.
My lord, when they gave it to us, when they gave us a draft, yes, and we corresponded with them, and they took 2 years to reply. And the learned single judge records that there is delay on their part also.
So thereafter you were put to position.
No, my lord, I was put to position much before.
Must be.
Yes.
By allotment later.
Yes, and there is a separate possession certificate also given to me. And admitted position that I have been put in possession even before the execution of the lease cum sale agreement.
Now, to which stipulation in the allotment do you have a grievance?
My lord, I had an agreement. Basically, my lord, we have written some letters, but today my instructions are. My lord,
Yeah, all right. But all these years,
my lord,
did you take up the
20 well, our
contention you are
grievance-
against
our principal
employment to the
grievance was-
Kannadigas?
Principal grievance was with respect to 20A because it stipulated, my lord, employment, because employment is not by a unit in Bangalore, in Karnataka. It is a national bank.
So your bank is, we want to know.
Yes.
Clear cut
Yes,
language.
yes, my lord.
We are putting it now. Are you against granting employment to the Kannadigas?
There is no.
That's the question.
The answer is no.
But where have you taken up that contention?
My lord,
Your contention
initially
is
we had
contrary
said-
all through.
My lord, that is not the issue in the case today. The issue in the case is not that respectfully. The issue in the case, my lord, principally revolves around the application of 35B. And now please see this judgment, my lord, of the division bench of this court. We are not on the question as to whether I am right or not. I have so many answers to what they are saying.
34B.
Yes, my lord, please, that judgment, my lord, of the division bench. Have you given the copy?
Does it go with your prayer to execute the sale?
My lord,
How does 34B?
no, my lord, 34B is action. If they have to take action against me for cancellation of the lease and resumption of possession, they have to follow the procedure prescribed under 34B, which admittedly has not been done. The question is whether 34B applies or not in the absence of a lease cum sale agreement.
Oh.
That's the question.
So
And-
that the doctrine of part performance comes into play.
My lord, part performance, in fact, the division bench of this court in an earlier judgment has approached in a slightly different way. Therefore, my lord, may I trouble your lordship to kindly see the judgment. The division bench seems to think that possession is delivered, payment is made, even without a lease cum sale agreement, there is a relationship created.
So interest in lease is created.
Yes,
Proper-
kindly see, my lord, that judgment in paragraph number 9, it's a short paragraph. My lord, it requests examination, my lord.
Question is, how can we oppose employment condition, the stipulation that you should give employment to the Kannadigas?
No, that's on merits, my lord, that's a decision which they have to take.
No, we want to know. It's not like that. If your client is against granting employment to Kannadigas, then we have difficulty in this court.
There is
But
another.
it's a stipulation. ಇಲ್ಲಿ ಲ್ಯಾಂಡು ಇಲ್ಲಿ ನೀರು ಗಾಳಿ ಎಲ್ಲ ತಗೊಂಡು ಅವ್ರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡಲ್ಲ. We don't understand
I am
logic.
here before your lordships on the question of law as to whether the only ground on which the learned single judge has non-suited me is on the ground that 34B violation
No,
does not.
if you are saying that in wake of section 34B,
Yes,
lease interest is already created
yes, my lord.
in your favor,
Yes, my lord.
then why do you seek the prayer of execution of lease deed?
No, my lord. Kindly now therefore see the judgment. Kindly therefore see the judgment of this honorable court for the purpose of 34B. My lord, please see the judgment, my lord. I think I'll be able to persuade your lordships to take a different view on in the place of the prima facie view that your lordships have taken. Please see this judgment. Now, this is an appeal filed by the KADB. The appellant, well, I'm just reading the first paragraph and then I'll straight away come to para 9. The appellant was the respondent in company application number so-and-so. Electromobiles was ordered to be wound up as per the order dated so-and-so, and the official liquidator has been directed to take over the assets of the company. The company in liquidation filed company application number so-and-so under 446 of the Companies Act for quashing the order of cancellation of allotment dated 30th of January 1987, 2/2/1987, passed by the appellant. The facts leading to the cancellation are as follows. The company filed an application on so-and-so to KDB for allotment of a land to construct a factory for manufacturing two-wheelers, three-wheelers, etc., operated by electric power. KDB, the appellant here, initially allotted 69.25 acres of land in so-and-so industrial area. As there was some litigation, the land in Hubli Dharwad industrial area could not be delivered. Therefore, KDB made a fresh allotment of land at Belawadi and delivered possession of 35 acres, 29 guntas of land, possession certificate and dated so-and-so, and an extent of 4 acres, 36 guntas on so-and-so. According to the board, the company was given time to 2010 to the 1985 to implement the project. As the company failed to implement the project within the time, the board at its meeting dated 7/1/87 took a decision to cancel the allotment made to the company and accordingly issued a letter dated 30th of January 1987, 2287 to the company informing the company about the decision to cancel the allotment for non-utilization of the land in terms of the allotment and calling upon the company to deliver back the original possession certificate. By the said letter, the company was also informed that 25% of the amount paid towards the cost of land stood forfeited. On the order of winding up, then Malad winding up order, official liquidator comes into the picture. Now, please be kind enough to see para 5. The feeling agreed, the board has filed this appeal, contending that the cancellation order is valid and the board cannot be prevented from taking possession in pursuance of such cancellation. Now, Malad, please be kind enough to turn to paragraph number 9. The order of cancellation was passed on 30th of January 1987, prior to the order of winding up on 9/4/87. It may not be possible for the official liquidator to contend that the board had no power to terminate the lease prior to the order winding up. But as noticed above, the order dated 30th of January 87 is not a termination of lease, but cancellation of allotment. When the allotment is on lease cum sale basis and possession is delivered to the allottee in pursuance of the allotment, the allotted becomes a lessee irrespective of the fact whether a lease deed is executed or not. Hence, the board could not have attempted to resume possession by merely cancelling the allotment. Now, my lord, at the time when this judgment was delivered, 35B had not been introduced in the statute book. That provides a special remedy only. But the fact remains that merely because a lease cum sale agreement has not been executed does not mean, my lord, that there is no lease. This is the law.
Where is the allotment? Where is the allotment, impugned order of allotment?
My lord, impugned order, my lord, is Annexure A.
Whether that does not amount to termination of the lease at all?
It may.
That can be.
I'm not saying no, my lord. I'm not saying it does not.
Yes.
Exactly what I have challenged. I have said you cannot do it without following the procedure under 34B. That is the contention, my lord. And the learned single judge says that.
Where is that in order which you had?
My lord, that is Annexure A, my lord. It is available for your lordship's consideration at page 89, my lord. Where is it? Page 89. My lord, is it available at page 89? My lord, all that 34B does, 35B does, is to introduce a special procedure. But it has to be compliant. 34B has to be compliant. Now the question, my lord, is as to whether 34B can be circumvented or avoided. Merely because a lease cum sale agreement has not been executed, and that is the finding of the learned single judge. I respectfully submit, my lord, that in fact, my lord, I pointed out this division bench judgment to the learned single judge. Learned single judge observes in one paragraph of the order that this is before 34B, therefore not applicable. But it makes no difference. 34B is only a remedy. Now, page.
What is SLSWCC?
Well, that is the single window clearance agency.
So what
Under the Karnataka, that's not
Extension for what you are supposed to?
My lord, they had given a particular time limit, my lord, within the project had to become, we had to go for extension of time, which we will do.
For lease deed.
My lord, this is, my lord, a chicken and egg problem for me. I go there, they will say, do you have a lease? I don't have a lease, I won't grant extension. I come here, I won't grant the extension unless you get the extension there. My lord, where am I? My lord, the point that is to be considered, my lord, is with respect to the division bench judgment.
We cannot cancel the allotment. Too soft, even the amended policy.
Did you file a reply in the main?
You have filed your statement of objection.
Yes,
You filed a
my lord.
statement,
Yes.
You have filed a statement.
They have statement of objections. They have admitted my possession. And learned single judge, my lord, says that 34B need not be complied with. And the finding recorded, my lord, is contrary to admitted facts. This is the point that I want to place for your lordship. Please look at the finding recorded by the learned single judge. If your lordship will kindly turn to page 64.
Possession was yet to be given appears to be wrong because he admits that possession was.
And that is the whole basis on which the judgment has
That's
been
all right.
rendered.
But question is, the unconscionable conduct of the allottee,
that
that he does not want to give employment to the Kannadigas. That runs.
No,
there
my
are
lord, kindly, no. There is a slight, in fact, my lord, that was what was initially said. Thereafter, please look at page 169. Please look at page 169.
We don't acquire land of non-Kannadigas and do this. One page number
169, 169. My lord, land may belong to non-Kannadigas also. My lord.
No, that may be. That's not the question. There are judgments. The object of creating employment also. You acquire land of the Kannadigas and you don't want to give job to the Kannadigas is unconscionable. That will be stabbing the conscience of the Kannadiga people. That does not stand to the reason.
But that's the point, my lord, is then why have 34B at all?
Let us see.
My lord, please look at page 169. 170, my lord, if I may. This is a letter that we wrote to KIDB. The banking regulator has since removed all fine. No, my lord, there was a problem with the Reserve Bank. Reserve Bank said we should not do any capital investment. Therefore, that also stalled the project. Now, my lord, we have got out of it. Therefore,
Where have they taken up the contention that to Kannadigas will not, the condition should be deleted?
Page 65, page 65, my lord.
65.
Para 70, it is rather surprising that the submission is made by the learned petitioner. The bank had objection to clause so and so, which is mandated the appointment of Kannadigas only as a personal office. It is ununderstandable as to how, no, let me complete. It is ununderstandable as to how this could be objectionable as the official language of the state is Kannada and the communication or correspondence to be smooth of the board as to clause in every lease cum sale deed agreement. If the board has imposed that only Kannadiga should be employed in the entire bank, it was altogether different circumstance. What is sought is only one office or a personal office to be Kannadiga. If this is objection to operate
one single officer to be Kannadiga.
No, that is the mistake he has made. That is the mistake the learned single judge has made. My lord, it is not with respect.
Where is that condition? Take us to the
No,
condition.
one minute.
Let us see the condition.
My lord,
Stipulation.
learned single judge has looked at 20B. He ought to. Learned single judge has wrongly looked at 20B. He ought to have looked at 20A. The grievance was not with respect to 20B. In fact, please look at our letter requesting, my lord, for the changes. Please be kind enough to turn to. That chart. My lord, kindly turn to page 219, my lord. Please see the changes that we wanted. Whoever talked about 20B. Give it to me. Well, please see page 219. But may I trouble your lordships to kindly see page 219? Please see page 219. What is the change I wanted? But it has nothing to do with the personnel officer. I don't know where it has come. Please see page 219. On multiple grounds, if I may say so with due respect, there is an error in the order of the learned single judge. Please see page 219, Manoj.
We are ready to abide by 28.
Manoj?
We are ready to abide by 28.
Grievance was with respect to 28 and I'm now ready.
No, we are asking you.
Yes.
Are you agreeable to give 80% employment to
Answer is yes.
Kannadigas?
Answer is yes.
No.
We have said so. In our earlier, let me point out one by one, my lord. Please be, my lord, I understand, my lord, your lordship's emphasis
No, not
on
that, not that. We are not that, this we understand Deep Bhatia. That also, that's another thing. The question is, the land of Karnataka, land of Kannadiga.
I am not.
And you don't want to give, you take land, but you don't want to give.
I am not, I am not on that.
Reasonable.
I can't resist all that. I can't resist. I bow down to what your lordship is saying. No, but please be kind enough to, first of all, let us get the facts right, my lord. Got the facts wrong.
That's all right, that's all right.
But you are not disputing 28.
Malad, I am not disputing 28. No, I wanted a change. Malad, I wanted a change in 20A, not in 20B. Learned single judge sings about personnel officer, one person.
That is the objection.
No, I am ready. That was not my objection. Kindly see page 219.
219.
My lord, my point is made when I showed your lordships 219.
Kannadiಗರ land, ನೀರು, ಗಾಳಿ ತಗೊಂಡು
Please keep that point. I will satisfy your lordships, if I may say so, my lord, rightful emotion.
219.
219. This is a letter that we wrote to KADB on 27/6/2016.
219.
Please refer to your letter number so and so, forwarding as a draft lease cum sale agreement for execution in respect of plot number so and so.
1 second.
I'm sorry. Oh, I'm sorry. I apologize, my lord. 219.
Second volume, part of the volume.
Your lordship will get it at page number 145 also. 145 also, my lord. Can you refer to page 145, my lord? Same document is there.
In fact, there is one famous Galagana, great novelist, who wrote. There is a famous novelist, Galaganath. Galaganath ಅವರ ಕಾದಂಬರಿಗಳು, 7 volumes. He says, ಕನ್ನಡಿಗರಿಗೆ ಕನ್ನಡಿಗರಿಂದ ಆದಷ್ಟು ಅನ್ಯಾಯ ಬೇರೆಯವರಿಂದ ಆಗಿಲ್ಲ ಅಂತ ಬರೀತಾರೆ. Yes, he used to print books and carry them on his head, sell to people, bring back that money, bring atta and eat the food.
In fact, if I may extend that also to one other thing, the greatest disservice that has been done to India is by the NRAs residing outside.
To that extent, we don't go. So far as at least Karnataka.
That's why I said I'm extending it. I'm extending it. Because so much is said against our country by our own people.
Page 144.
That is also, anyway, my lord, this is just a reaction to what your lordship said. Well, please see page 219.
No, page 144, the same document.
All right, say okay.
219.
Okay.
Yeah,
The court doesn't have the
219, my lord. Please,
Yes, please read.
this is a letter that we wrote to KADB.
This you sent it in 2016.
Kindly now see that letter. I want to point out what was our objection first, so that then your lordship will kindly see the next document. I want to show to your lordships. Please refer to your letter number so and so, forwarding to us the draft lease cum sale agreement for execution in respect of plot number so and so. We had forwarded the lease cum sale agreement to our head office at Mumbai for permission to execute the same with KADB. In this connection, our head office advised us to seek modifications at certain clauses as indicated in the annexure. We request you to look into our request and grant us with the required modification so that we may execute the lease. What is the modification, my lord? Please be kind enough to turn the relevant one at kindly turn to page 223. Yes, we sought only with respect to 20A. Not personnel officer and all that, that is hardly an issue. And all that we are saying, look, consider this, IDBI is a public sector bank with the recruitment being centralized. It will not be an industrial unit. The class may kindly be removed.
You say you will give class C and class D employment to these people, but not in the higher. They
We
should
have
be
said we reserve
sweepers,
100%.
tunes. Huh?
We reserve 100%.
What is use in having 100% tunes? All 100% tunes. How that is going to serve the cause of Karnataka? Please.
I understand, Mulad. No.
We will, it is like Robert Clive saying to the British Crown that I shall be the Governor General, and he was also, and he will appoint all native people in the Group C. Read Robert Clive, Clive of India by Niraj C. Chowdhury. It is as good as that.
Yes, sir. Now, Mulad, first point, Mulad, I absorb everything that your lordships have said on this issue. But the point I'm trying to make is slightly different.
He wants to give employment. Tunes, sweepers.
Go to read the answer.
Curtain drawers to Karnataka. Rest of the people he wants to have from your, his cadre.
Okay. Ali, there is a slight misunderstanding. This second column is what they have proposed.
No, you said we have proposed, and you said
No. Kindly see, what this 100% which about which your lordships have been telling me is not what I proposed. It is what they have proposed. Well, the second column is what has come from them. Let us be. That's why I understand the emotional.
Not
angle.
emotional.
No,
reasonable.
No, I will modify. Reasonable
I'll put it this way. He's
please.
saying, I will not give to anybody. Forget your class. Your lordship,
let us be-
page 223, right hand side, IDBI Bank is a public sector bank with recruitment center. It will not be an industry. This clause may be removed. Aurigu kodala, we will not give it. Well, what has happened now? No, third party allotment is already made to third party after cancellation.
No, my lord is saying, if he is agreeable to A, what my lord is asking.
Then what is the follow-up? Both of you just consider that. If we confine the controversy, to prayer A only, then what is the fallout?
Prayer A is
Yes, then I go down. In fact, I think I should be quite content
Because
with it.
the decision on the
Is well for them. All the time saying,
decision in
fact,
respect of the
may I suggest one way out, if it is.
My lord is saying something.
I'm sorry, I apologize.
the stipulation in the proposed, whether permissible or not, we are not going into it. The stipulations in the proposed lease deed or sale deed with the parties is a matter of subject of writ petition. Therefore, we are saying that if we confine the controversy and the adjudication of controversy, cooperative A only, then what is the fallout?
But what happens?
What is the fallout?
Yes, brother. I tell you, lordships, what the fallout according to me would be. My lord, in fact, I'm suggesting, my lord, a way out of this, so that, my lord, your lordships may see how 34B and all this. Your lordships may even say that the order that has been
And the
impugned.
law has one of the facet of customary law. Custom will include everything, including.
I am not for a moment, my lord, I am not, I agree, my lord. My lord, I am not on that, my lord. The question, my lord, is really the application of 34B
And
today.
if we go into the law, then whether can you object a condition in the lease deed, which is to be executed by them?
My lord, I may
What
not
are-
be, able to.
Is
I am-
it that arbitrary?
I may not be.
Is it that irrational?
My lord, but kindly see the reason why I may not be, my lord, but kindly see the reason why this cancellation has been done. Cancellation has not been
That
done.
is why we are saying that we confine the controversy to.
Yes, exactly. My lord, in fact, I
Think-
want.
Think it over, what can be
No,
done.
my lord, I have a suggestion to make, my lord. I have a respectful submission.
But there is one more aspect. Why you want only tunes and sweepers? This is the suggestion which you have given,
Correct.
arguably. You want Kannadigas to be tunes, sweepers,
That is what-
curtain drawers. What is this you are doing?
Correct.
Disservice to the state.
Absolutely. In fact, I'll suggest, I understand.
No, how,
I understand.
if that proposal were to come from them, we would have understood.
Your
They
lordship,
said
right.
we will not appoint is extreme condition that can be justifiable. for cancellation of the allotment itself.
That's
There
not the
was a
ground. That's
judgment.
not the ground.
Anyway, that is not the ground, but court can look into. We are not only that one, we will not go by only Mohinder Singh Gill. There is a lot of jurisprudence developed on that.
And that is why,
Anyway,
but the
that-
jurisprudence development not is only if there is a subsequent event, not, but
that's
Mohinder Singh Gill holds good.
That's all right. But point is, we in a appeal, intra-court appeal, you have to show not only the multiple errors in the judgment, whether the judgment is otherwise unsustainable. If suppose if the stand of your client is unconscionable to the act itself, then that is one of the grounds for denying relief
No,
also.
but the KADB cannot give a new reason in your lordship's court. Other than.
But we can generate. We can look into
I
papers.
respectfully submit, my lord, that is not possible for the reason that if I am right in my submission, that 34B is a mandatory requirement, then the principles of natural justice being violated is itself a right.
That's all. That we will consider.
The honest single judge has referred to the requirement of appointment of personal manager only.
Wrong. We have never contended that.
You are not against that?
No.
Your Lordship, may can we see page 139 for?
Anyway, now.
Then why should
my
we,
lord has suggested-
why should we go into all other aspects?
If you are agreeable, you consider that my lord has suggested.
Then it will be breach of condition, etc. in future.
Lordships are saying, I'll put it across, we'll get back, my lords. I'm not on that. With what fell from your Lordship, and what it says, overall employment 80%. It's not as if.
No,
Your
not
Lordship,
like- I have seen that.
No, page 130.
20 capital A.
What is called out is different from what is in.
20 capital, small a, I have very carefully seen it. I have concern for the state. I have
Can I
concern
read
for
it for a moment, 1
implementation
second?
also. Please.
Minimum 80% employment to Canada on overall basis.
Ah.
However, the lessee shall 100% jobs in case of C&D, 100% for C&D, 80% overall. So therefore, it includes all
runs of.
Runs if they are available.
Otherwise, it's meaning.
And I understand
If
what
they-
fell from.
But you should be very, therefore, you should be very clear. When it
Language
comes
is-
to protecting interest of the particular people of the state, your wording, your phraseology should
Must
be
be
very, very carefully done. You should
That
teach
it is-
people Kannada first, how to write.
Well, immediately I'll get it.
Otherwise, these things will happen.
ಇಲ್ಲ ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂದ್ರೆ ಕನ್ನಡನೂ ಗೊತ್ತಿಲ್ಲ ಇಂಗ್ಲಿಷ್ ಗೊತ್ತಿಲ್ಲ.
ಎರಡೂ ಗೊತ್ತಿಲ್ಲ.
The problem, my lord, is this. The problem is they neither know Kannada nor they know English.
Mr. Raghavan, apart from sentimental.
Exactly, my lord.
This condition is not that unconscionable.
No.
My lord, that now has become, kindly see page 170, the letter that we wrote subsequently in 2022. We said, yes, we'll do it
So it
as per your
appears-
standard terms and conditions.
It appears to be in the functional interest of the bank or the whatever you,
Yes.
the put to use, the use you may be. the
My lord,
land-
in fact, we have gone on record to say that we are now willing to sign it as per the standard terms and conditions.
No. When the matter was argued on 6 March 2024, the contention was the same. After having
No,
lost,
wrong.
now the,
Malad,
what
it's
was
wrong.
argued.
Malad,
before the
kindly
single-
see, the whole approach was wrong. Learned single judge has misunderstood the entire contention. He has gone on the basis of
No,
20B.
let
He
them
never
follow the-
contended that.
It is rather surprising the submission made by the learned senior counsel.
The whole thing was wrong.
No. It's a submission of senior counsel.
Malad, you are misunderstood.
Not.
Sorry. I mean, of course, Malad.
But we have understood what is
You
what.
all just understood. Malad, no. Malad, in fact, Malad, I have one suggestion to make. If it appeals to your lordships. Malad, the order which has been impugned, not a single judge order, the action of the KADB which has been challenged, in fact, may be treated as a show cause notice to me. I am willing to send a reply. Let them look at it and pass whatever. So that, my lord, I can then say, I can take a categorical stand. What is the position to me? That's all that I'm saying.
We say the KDB itself.
Let the KADB itself decide. my lord.
But
That's
now,
all.
but one.
Yes.
thing,
Please record
what
my
my
submission.
lord
I'm
Honorable
sorry.
Chief Justice
I am
said,
sorry.
Please bear that in mind also.
Yes, madam. Yes,
The 20 clause A is not unconscionable.
my lord, I am not even pressing it.
But you are saying that 20A is not in your perception at all.
20A, I am willing to abide.
That is the end of the matter. Mr.
20A, I am
Gabriel.
willing to abide. I have written, my lord, I have written a letter.
So now this, I don't know why this drifted to this different aspects.
My lord, I have written a letter. Kindly see page 169
So
and
he-
170, my
he-
lord.
That was in 2022.
He
My
only,
lord, much before this order was passed, cancelling the thing.
he only says that learned single judge wrongly focused on 20B.
Yes.
If that is so, then this can be reconsidered by learned single judge.
My lord,
Please, my lord.
Reconsidered by, or reconsidered by them also.
Yes, and in fact, the order which has been, the action which has been challenged may be treated as a show cause notice to me. I will send a detailed reply to them. Let them consider and pass whatever orders they want. So that, my lord, the facts are before them. They comply with the law also.
But subject to the undertaking that you will abide by Kannada.
Yes, my lord. Yeah, my lord. I will tell the bank in unclear terms. In fact, my lord, we are willing.
But we remand the matter to KIBD on what ground?
On the ground, my lord.
By setting aside that part of this observation of learn a single.
No, on the ground that they have to comply with 34B.
No, that legal position. I'll
That
satisfy
has
my-
to be done. I mean, legal position.
Then
No,
it
that-
requires consideration.
That requires
That's okay. ma'am.
Because of revision bench
If
judgment
the
of this
lordships
court.
are sending it back, it's a different thing to give an opportunity to consider. 34B is not applicable is my
That's a different
submission.
matter, madam. I am not hung up on the
34B is
section
Mr.
number.
Raghavan,
Point-
we go
point
by
of-
step, we go step by step. If you are saying that you are willing to abide by 20A,
Yes, I am.
then to clear that part of controversy, put it on affidavit
Yes. Say it in
on the
affidavit.
next day.
Yes, I will.
Yes.
I will do it, man. No, not an issue. I will do it.
Then how to mount the relief or how
Very,
to.
very, very. No, I go down. I go down. Your lordships may even record it and direct me to file. I will.
Shall we record it?
Yes, please record it.
No.
Yes, that he filing.
Please record it, man. So that the bank, let them look at it and then take the decision. Please record it. I will also tell them.
No, you said, you have affirmatively said to my lord's question
Yes.
that we will abide by 20A.
In fact, affirmatively, my client has gone and recorded even to KIDB that they are willing to sign all the terms and conditions of the lease.
Now, we are asking you,
Yeah, answer yes, my lord.
20A.
Yes. Answer is
Relating
yes.
to employment of Kannadigas
Answer
in
is
your
yes.
organization in all ranks.
Answer
That
is
will
yes.
remain intact. You said that.
Answer is yes. I stand by it.
The present writ appeal
You file that.
is directed against judgment and order dated 6th March 24 of learn a single judge. In which the post of learn a single judge dismissed the writ petition of the appellant petitioner. Paragraph 1 of the prayer. The writ petition was to direct the respondent
Page 85.
Karnataka Industrial Areas Development Board to execute a lease deed, lease cum sale agreement in favor of the petitioner in terms of the allotment letter dated 15 to 13. Full stop. In course of the hearing today, comma, some controversy arose in the context of the observations of learn a single judge, comma, as to whether the appellant petitioner is willing to abide by. Some controversy arose, comma, in the context of the observations of learn a single judge in respect of incorporation of conditions 20 into bracket small a and 20 and 20 into bracket small b in the proposed sale deed, which may be
See, lease cum sale.
executed. Draft lease, in the draft lease cum sale agreement, which may be executed as final lease deed. Full stop. It was submitted that the entire focus was required to be pinned, T-I-double-N-D, on condition number 2B.
20A.
20A, whereas learned single judge has adverted to the compliance or otherwise of 22B, which may be required at the end, END, of the petitioner. Paragraph. In order to steer clear this controversy, our learned senior advocate, Mr. K.R. Raghavan, for the KG Raghavan, for the appellant, stated that the appellant is willing to get incorporated. Condition number 2A. 20A. If the lease cum sale deed is to be executed in favor of the, while executing the lease cum sale
agreement.
in favor of the appellant. He also submitted that the appellant will abide by what is contemplated in condition number 20 capital A, full stop. In all fairness, paragraph, learned senior advocate further stated that he would file affidavit to the aforesaid effect by the competent authority, through the competent authority of the appellant on the next date, full stop. Stand or to.
The status quo may be maintained because if they disturb the
See,
possession, my lord.
The reason I also suggest that the reason is, my lord, I'm giving just now, they have allotted to somebody. Let status quo be maintained so that we can.
Whatever
inform-
status quo, I don't know.
I'm saying.
Both sides.
Both sides, because tomorrow, my lord, it should
Stand
not be
or
that
to.
you're not.
Which date?
My lord, any day in the first week of June, my lord.
5th June,
7th or 8th. 7th or 8th.
7th or 8th? And 10th June. 10th June. Both the parties are directed to maintain status quo in relation to the subject matter, land.
Land.
So we'll thresh out.
Yes, great.
Complaints in contempt matter, number 36, to G.R. Mohan.
Taken up at 2:30 today, my lords. The matter was to be taken up at 2:30 today, as per the previous order, my lords.
April order, they have to. We'll consider.
They're not complaining.
You just find out some ways to implement the order.
Yes, ma'am.
We understand the practical difficulty still, since
Yes.
it is an order of the court, you have to find out some.
Yes, ma'am.
So you rigorously discuss with the commissioner
Yes, ma'am.
how to get out the.
He'll be present
how
at
to get out
2:30
from the
minutes.
contempt.
He'll be present in court at 2:30 minutes.
You must take some steps to show that you are bona fide complying with the directions.
We'll look into it further. Yes, my lords.
We understand that taking into logical end is bit difficult.
Great remembrance.
And one submission, correction, it's the order of the division bench, your lordship.
How
not the
many shops
international
are
bench.
there in the?
47, my lords. 47.
So have your car in the first gear at least.
We'll do that.
Some movement.
The matter will be taken up at 2:30, my lords. So
We'll, after vacation.
After vacation, we'll have.
12th
my
of
lords.
June.
Lordship, the correction has to be made in the 16th April.
It will
The order of the division bench, not the learned single judges. It's a division bench order in APA.
Order.
Paragraph, first paragraph in the order,
Makes no difference.
Which one?
division,
It is not that 1+1.
the order of division bench. Some date may be given. Lordship.
12th of June.
Please.
Hearing on applications, seal number 37, Mr. Mohan S.
Hearing for complaint in this case, my lord. The complainant had filed a complaint. Making allegation against the respondent that they have violated the order. On 28/3/2024, the complaint filed was disposed of. In the order, it is observed that the
So it is spoken, being spoken.
Application.
Which application? So the order in application IA 1 of 24. It could be noticed from the contents of order dated 28/3/24 asked by the court that the interim order dated 14/9/23, which is referred to in paragraph 2 of the order, is passed by the division bench of this court, whereas what is transcribed in the second paragraph of the order is that the order was passed by a single judge. The above error of transcription shall stand corrected by deleting the group of words in paragraph 2 of the order, which inward comma, order passed by a single judge. And the group of words, order passed by the division bench, inward comma, shall stand substituted. The order shall be corrected accordingly and reissued. Full stop. The application is accordingly allowed.
Number 38.
For the petitioner in this matter, my lord,
P. Sundararaman.
in the last date of occasion, the counsel for respondent had filed a inquiry report in this matter. It was placed before this honorable court. It was also opened, the seal cover was opened, so I request for an accommodation, my lord. Maybe kindly had after vacation.
I have filed an application to implead some of the associate members, my lord. There is an order of restraint as to allotment in their favor. So I may kindly be permitted to come on that order.
After vacation. Kindly have the matter after vacation, my lord.
I appear for respondent number 1, my lords, the Cooperative Society. I may be pardoned for not being able to appear in person, my lords.
Yes, so
A
we are
date may
keeping
kindly
it
be
after.
fixed. my lord. A date may kindly be fixed.
Date may kindly be fixed.
Date will be given, 18th of June. You are also appearing.
1 and 2, my lord.
18th of June.
Much obliged.
Oblige, my lords.
39.
Lordship appear for the
Rohan Patari.
petition corrected matter 39.1 and 39.4. And
may I
last
submit?
occasion on 20th March,
Sir,
the
on the last
BBMP has filed a
occasion,
memo.
I filed an affidavit which
For
was
that,
also
I have
supplied to the other side.
file my reply, short date.
Wherein
Because they
want
want
to
to
file reply.
modify the order of this court earlier. The short date may be given so that immediately after vacation, any date.
Please go to 26th of June.
Please.
Is old matter 2014.
Does it pertain to
19th June.
encroachment on storm drain and lakes?
PIL.
PL. Batch of petition.
11th June. Obliged.
Because after 2020 order was passed by this court, no permission can be given for a private.
You are sought for
So
time, we
for
have
that-
granted,
so
still
they
you want to
want to
argue,
seek
you waste the time of the others. Yes, please.
11th June. Number 40.
I appeal for respondent number 7, your lordship.
My lord, for the petitioner, my lord. Appearing party in person, my lord.
Kushal Kumar Kaushik, party in person.
First time, no notice is ordered, that's it.
Notice has to be ordered.
Only R7 and R3 are on record, my lord.
Meghalaya court held to be this one.
My lord, and that apart, the intention behind this petition is, my lord, to regulate the practice of Asti Visarjana. We are not seeking a ban on the practice, my lord, because the concern is, my lord, the allied practices of Asti Visarjana, that is of dumping of flowers, plantains, and also
Asti Visarjana is the he wants some.
My lord, if I may just take this quote to Annexure J, my lord, just in August 2023, in a parliamentary reply, even the Minister for Forest and Environment has noted that there were 28 different locations in Kaveri, on the banks of River Kaveri. Tests were conducted, my lord, and it was noted that the river water is above, the drinking water is above 6 ppm, my lord. That means, my lord, it is not fit for drinking at all, my lord. And the practice of Asti Visarjana, my lord, is being conducted throughout the banks of the river. Initially, my lord, there are only 2 locations, my lord, at which Asti Visarjana was being practiced. And
do you have that Meghalaya judgment which said the river is a living person?
I apologize, my lord, I haven't brought it
such
with
a
me, my lord.
judgment, na?
Yes, my lord, I have referred to that judgment wherein.
Get that judgment.
Get that judgment.
Yes, my lord, I have also pressed for an interim order, my lord.
No notice, no interim order. Right now, we bring that judgment. Immediately on reopening, we'll clear. There is no urgency in that.
My lord, the urgency is that, my lord, the practice of Asti Visarjana on private properties is also happening, my lord. Initially, my lord, and that apart, my lord, if I may just take this quote through annexure.
The private property issue then separates, not the PIL at all.
No, my lord, on various different private properties.
So Asti Visarjana has been happening since Vedic period. It's
Yes, my
not that from yesterday it has begun and therefore everything will be this one. There are some judgments. Look into that, because right to decent burial is recognized by the apex court as one of the rights falling under 21, even in respect of dead people. Look into all that and come back.
Yes, ma'am.
All frugal.
My lord, date may be fixed, my lord.
December 41, to B Pramod.
They should be capable of attribution of rights. Otherwise, it's meaningless. So, summoned on jurisprudence, teach the subject, expert consequence.
December 41.
I appeal for the appellant, my lords, respond.
And there is
Lords, I appeal for the appellant, my lords. Respondent has filed this application for early hearing. My lords, may kindly peruse the previous order, my lords, 2/1/2024.
hearing. Interim order was granted after hearing him.
After hearing both, it was admitted. Last time they had filed one application, my lords. Order is passed on that also on 2nd of January 24, my lords.
It is already ordered in due course. Any pressing urgency?
December 42, the Narendra HN.
In this matter, we have complied. Order has been complied. 42.1 is the contempt petition. 42 is the appeal.
So what you have complied is subject to outcome?
Subject to outcome of the appeal, you have complied. No,
Then-
appeal has to be heard in the matter. Appeal to be taken up for consideration. No, no contempt, because appeal is there.
No, attempt, I am filing my objections to the appeal. Appeal is not at all to be sustainable. I am filing my objections.
Whether order is complied with?
Yes, Lord.
You have complied with?
Yes. The direction is to reinstate, that he has been reinstated.
Also filed that complaints affidavit, my lords.
Annexure R3 may kindly be seen.
In your reply statement?
Yes.
So we take it after. So your compliance is after filing your appeal or before filing?
Before, my lords.
Before filing of appeal?
You have complied.
So when we have filed our complaints affidavit, my lords, where we have reinstated the complainant.
We'll see
Grateful, my lords.
20th.
They have reinstated, no doubt, my lord.
After vacation, we have taken.
Consequential benefits are to be paid.
All right, we will take up both the matters after vacation.
Grateful, my lord. Shall file my objections also for that.
You file it. in
Copy may be
office.
self filed.
20th June. Number 43.
Grateful, my lords.
Yes, Kalyan Basuraj.
Waiting for the appellant's counsel. The appellants were not parties, my lord, before the learned single judge. They have filed an application seeking permission to file this appeal. And there is a delay in filing the appeal, my lord, because we came to know, my lord, very subsequently. Immediately on coming to know, my lord, this appeal is filed, seeking permission of the court, my lord, to file this appeal. The short controversy involved, my lord, is 1 acre, 20 guntas of land.
After
Notice, my lord, has to go, my lord, to the respondent. Notice to the respondent. If my lords permit, my lord, we'll take notice to the respondent.
Notice to response.
Please.
Tenable on 20.
On all
20th?
On all three appeals, my lord.
All the.
In all the appeals?
Yes.
3 appeals.
3 appeals.
There is one application, my lord, for restoration, which was dismissed for default.
44.
Recalling of
Restoring, yes, recalling and restoring.
Recalling of the order.
They arise out of the common order.
The writ appeal was dismissed for want of
Yes.
non-removal of office objections. This application is filed seeking recall of the said order dated 29/5/23 paragraph. In the facts of the case and in order to enable the appellant to contest his case on merits, comma, the application is granted, the order dated 29/5/23 is recalled. Full stop. Whatever office objections are left out to be removed shall be removed within 15 days.
Please.
Application is there accordingly.
In respect of R6, third matter, Chandrasekhar. Please. When some respondent is dead, you have to take steps in respect of them. R6 is dead.
Number 44. Satish K.
Counsel for respondent in writ appeal minutes. May kindly request your lordships to pass over minutes.
Then beyond vacation.
Pass over.
After vacation.
There is urgency in this matter. Minutes are filed IF for modification of interim order. The learned single judge minutes had granted minutes that no fresh tender will be issued by the applicant, but if
After
due to-
vacation means.
due to the interim order of this honorable court minutes, fresh tender may be issued. There's some urgency minutes. May
It
grant-
can wait.
About 45. Number 45.
For the
Jay Kumar.
respondents. This is with regard to payment of that back wages with effect from
10%. 10%.
1/4/21.
Then,
It's paid
Up to, now I have obtained information of 8%, 2% were not paid. And now council is informed that them, for them also paid.
All
That
are
is
paid.
their- that
All
is
are
their-
paid.
contempt, only one person has filed.
Only that.
But we have complied with the,
others
this for
also.
all the 17
All 10% are filed complaint, contempt. Out of 8% had already received the information they are received. Another 2%, the council is telling they are also paid. If that is the case, it may be
He's the
closed.
complainant. Complainant's case is before us.
Please.
Others in market.
No,
we are not-
10% are complainants, my lord, not one. 10% are complainants. It's not 1%. Another is 7% they are filed, that is not, I'm not on it.
No, he says payment is made to
We-
everybody. We'll record that and we'll drop the proceeding.
Learned advocate of the respondent, so and so.
No, last time your lordships have passed the order.
For compliance dated 23/4/24. He further makes a statement that not only the complainant hearing, but all similarly situated employees have been paid the salary dues.
Difference.
Salary dues.
Arrears of salary.
Arrears of salary. Full stop. In view of the above, nothing survives in the present proceedings. Contempt proceedings are closed and disposed.
Please.
Number 46, Mr. Ramakrishnan, 14%.
Fourteen person was absent. In the interest of justice, turned over to 2nd July. Registry shall intimate.
Connected method.
Is there?
Number 47. Javanappa.
Have your speaker.
Appear for complaint, my lord. Appear for complainant. Notice is served to accused. Accused will not come.
Not compliant. What is not compliant? Yes, who will appear?
He is appearing despite service of notice chief.
Take notice, Mr. Mahindra.
Mr. Mahindra.
Yes, to take.
Some officers are there, no, accused persons have to take notice. Despite service, they are not represented.
46, Mullah. 40.
Panel advocate.
KPSC.
KPSC.
Prakash, BN Prakash. BN Prakash. But they are served. Served.
Who is to comply? Who is the actual authority to comply?
My direction is the complaint is selection to the post of motor vehicle inspector. My lord.
Who appears? No, normally. Full stop. Those served with the notice. None appears with respondent. Full stop. It is respondent two which is supposed to comply with the direction. Full stop. Before the court takes a serious view. about the non-appearance of the respondent despite service of notice, comma, an opportunity is granted, full stop, paragraph, learned advocate for the petitioner shall supply the copy of the contempt petition to learned advocate Mr. Prakash, who normally appears for respondent two in this court. Learned advocate is directed to appear and assist the court on the next date, put up on 11th June.
You give copy?
Yes, my lord.
To Prakash.
Yes.
Lord's kind permission. ಎಲ್ಲ ಹೋಗ್ತೀಯಾ ಬರ್ತೀಯಾ ಏನು ಅನ್ಸುತ್ತೆ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಬ್ಮಿಷನ್ ಟೈಮಲ್ಲಿ ಮ್ಯೂಟ್ ಆಗ್ಬಿಡ್ತು. ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಯೋ ಮ್ಯೂಟ್ ರಿಮೂವ್ ಮಾಡಿ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಏನಾದ್ರು ಟೈಮ್ ತಗೊಳ್ತಾ ಇದ್ದಾರಾ? ಹಲೋ ರಾಜು, ಯಾರಿದಾರಪ್ಪ?
ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್. ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
Number 96 for withdrawal of writ petition PA.
My lord, I am the petitioner in this case, my lord. I have filed a memo for withdrawal because the writ petition itself has become infructuous.
You the advocate also?
Yes. 14.
Oh, 14. So you're withdrawing, Mr.
Uh,
Mohammed Dastagir.
Yes, my lord, I am Mohammed Dastagir. My lord, I have
Withdraw-
filed this. I have
Withdrawing?
filed- Withdrawing, my lord. I already filed memo also, my lord. It is on board.
It is the part in person, Mr. Muhammad MOHA WMED Dastagir. It's attention of the court to the memo filed by him. Where is that? Dated. 5/2/24. It is stated there in paragraph that in the petition, the grievance was with regard to illegal collection of super fast charges from the passengers traveling by train named Malgudi Express. It is further stated that in view of the passage of time, the prayers in the petition have become infructuous. And in view of the subsequent development, the petitioner is not willing to, does not intend to pursue with the petition any further. Accordingly, permission is paid for to withdraw the petition. Paragraph. Learned party in person appeared through video conferencing and with reference to the aforesaid memo requested the court to permit him to withdraw the petition. Permission is granted. The petition is dismissed as withdrawn.
Your lordship.
Number 48, Sangamesh RP.
For complaint is. This has complied.
Complied,
Not complied.
not complied.
It's a
After
Prodi and Durasti.
After it.
Date may be given.
They'll comply.
Third round of litigation. Third
Third
round
of-
of litigation.
3rd of June.
Third round of.
Third round. Mr. Do it.
Please,
Compliance has to be done.
complaints, blood, presence may be ordered next date.
11th June.
49 urgent, number 50. Then they.
I have filed an application for vacating the status quo order, my lord.
I'll file my lords and I'll file my objections, my lords, to the IA for.
It is not so, my lord. Your lordship may kindly see the order dated 9/1/2024. Issue notice to respondents returnable by 16/1/24. By way of interim order, the parties are directed to maintain status quo as on today. The parties are put to notice that on next hearing, date of hearing, it is convenient, if it is convenient to the court, the appeal shall be heard and disposed of on that day. This matter, my lord, relates to the administration of a college. And there is too much of corruption in the college by the present appellant. And certain old students filed an application for the registrar of societies for appointment of an administrator, because the college actually belongs to a temple.
Appeal will take up.
No, my submission is only this, my lord. I may be permitted to move before the vacation bench.
You move, nobody prevents.
Unless the permission is granted.
No,
it
no,
will
that
not.
is not so. You can move independently.
Please, well.
And satisfy the vacation.
Please,
checks
well.
about the-
Please, well.
Interim order may kindly be extended, please, ma'am.
My
Interim
submission is,
order shall continue.
if the interim order is extended, my lord, the college is going to be closed. There will be no absolutely democracy in the college. From 1,800 students, the students have come down to 300 now. With much difficulty, 50 years back, the college was started by a few philanthropists. One person has entered inside and he is doing absolutely nonsense. That is the reason administrator was asked to be appointed. Once the order was passed, my lord, he has again started the same.
We'll consider 20th June.
Please.
Interim orders may kindly be
Interim
extended.
orders will continue till the.
Grateful to my lords.
Seal number 51. 51.
Beyond that.
52, 53 adjourned. Seal number 54.
The appellant, my lord, I'm only aggrieved, my lord, by the direction at page 34. Lord, my writ petition is allowed, but a direction is issued.
Page 34.
Page 34, my lord. Last paragraph, my lord, of page 34, my lord, this originally, my lord, is challenged to an industrial dispute. After, my lord, settlement had been arrived at, second dispute was raised. That was challenged in a writ petition. Writ petition is allowed. But, my lord, the labor commissioner is directed, my lord, to open a reference with respect to, my lord, the dispute to which the employer is not a party, third party. It is not an industrial dispute. And, my lord, direction is that he should open a reference and adjudicate.
So this Godrej, who is what? Godrej
But
property?
my lord, he purchased a part of the land belonging to the factory. My lord, I was making incandescent bulbs. The factory closed down because of, he has nothing to do. He is not an employer.
What was the dispute negotiated, conciliated?
My lord, the dispute was with the employer, my lord, earlier. There
Your
was a
employer.
settlement. I paid. I am the employer.
Oh.
I have paid. My lord, now, in spite of the payment having been received by the 444 employees, my lord, second reference was made, which I challenged in a writ petition. The writ petition is now allowed. But there is a third party, my lord, who is not an employer. At his behest.
So this direction at page 35 was part of the prayer?
No.
So how come they learn a single?
Cannot be conciliation.
So this, if this is deleted, then everything is.
If this goes, you are happy.
Yes, my lord.
No, I request for a date, my lord. My senior colleague has been held up in the water matter.
You appear for whom?
I appear for the respondent number 2, my lord.
Which respondent?
Union, my lord.
Union. How you are concerned with this dispute?
Lord, the workmen's, my lord.
Union, see that Industrial Disputes Act by Malhotra. He says, he writes in that edition, I don't remember which is the page number. He writes, the conciliation can be only between the management, the employer and the workmen. It's so simple, it does not require reiteration also. How you are concerned with this?
My lord, yeah. According to the order of this writ petition, my lord, already the workmen have received the compensation as well.
That's all.
The appeal has become
This is
infectious.
conciliation between third party. The very idea of conciliation arises as between the employer and the employee. It cannot be anything else.
They were the purchasers of the property.
So they have deposited the amount.
They have deposited
But,
and it has been released as well. my
Towards,
lord.
Lord, it's a county, I have no, Lord, I am not involved in that process at all. Lord, an independent person is directed to deposit money before the labor commissioner and he is supposed to conciliate.
the delay is there.
Delay is there. Notice
22 days, my lord, notice had already been issued.
Issued, but not served.
Served, served.
Served also.
They have not filed any objection.
So delay can be counted.
Delay can be.
Delay may be come down, my lord. Insofar as the stay application is concerned, I pray for a date, my lord. Because already.
There be,
the
my lord,
writ appeal has
stay of
become
proceedings,
infectious.
my lord.
Because, my lord, there are 444 workers, my lord.
It's all right. O.P. Malhotra writes on Indian Industrial Disputes Act. There is a commentary. One paragraph says, the first volume, the conciliation can be only between the employer and the workmen. That's the law. That's how it has been structured.
So today we condone the delay.
Yes.
Please.
Delay, we'll pass the order. What is the delay? Extent of
May I
delay?
seek, my lord, the stay of Further proceedings, my lord, pursuant to the
Other
order.
side is not there, they would, we are with
But
you.
is there
Time of
not-
essay.
But palpably, my lord,
22, acha, write down. IA number 1 of 24. This interim application is filed to condone the delay of 22 days. Full stop from the averments made in the supporting affidavit. Sufficient cause is made out to condone the delay to the extent of 22 days. Therefore, delay is condoned, application is allowed. Writ appeal shall be listed on 13 June.
may I seek stay of further proceedings, my lord, till the next date. Let him not, my lord, because it's palpably a wrong
Only thing,
order,
will be
contrary
a-
to the statute.
Will be passing in absence of the others. That's what. That is the only.
By definition, my lord, industrial dispute is defined as, my lord, between
You
an
are
employer.
right, but bring your friend and catch hold of your friend and bring him.
Fifty-five, 56 are urgent, seal number 57 to Bhargav N.
This matter counter has been filed. But
Three months of order was passed, my lord, to do it within 3 months. Appeal dismissed, SLP dismissed.
intention in the counter affidavit is that not COD has seized all the documents and produced before the criminal court.
This is contempt.
Contempt. Yes, Lord. The
Criminal-
direction is to not
Implementation.
implement the order passed in civil,
After-
passed by the civil court in OS.
After.
Number 58 urgent, number 59.
59, my lord, appear for complainant, my lord. My lord, page 17, my lord. Para 7. My lord,
Counter is
am I
filed.
audible, my lord?
Counter is filed.
It is covered by the judgment of this honorable. Act 7 of 2014.
Sir, still pending.
My lord,
Special bench.
kindly grant the liberty after disposal of liberty for revival after disposal of writ appeal, my lord.
This is.
No
this
question
is
of
dif-
going before the learned single judge.
This is different.
Disposed of matter. No, you have given some different matter.
I'm
Other
sorry.
yesterday, you had given that
Yesterday.
judgment. Give that judgment. This is not the judgment.
I'm sorry, my lord.
My lord, with liberty, my lord, for revival,
Correct.
it may be disposed of, my lord.
I'm sorry.
Am I audible, my lord?
My apologies, my lord. The counter affidavit we have stated, my lord. So far as A-date period is concerned, we have settled everything.
Yes.
Urgent syllabus 61.
Address.
Venkatram Reddy L.
61 is against the interim order, my lord.
Who appears? 31st.
Presence of the officers was directed. Presence of the
Directed,
officers
my
was
lord,
directed.
on the last occasion they were present.
No, we are
This-
asking, were they directed?
No,
Because they
no,
are here. No,
this
no.
time.
31-5. December 62.
Lord,
I
this may
filed
be disposed
application
of.
for
Lord.
correction of
61,
the-
61, Lord, it is against the interim order.
Same order.
But nobody is there.
No, he's here.
I'm here.
60,
I
you're
was
60.
permitted to correct the name of the accused number 1 and 2, wrongly mentioned. Madam. I filed application for
62
correction.
is also interim order.
The name of accused number 1, Pramod Patil instead of K. N. Dayanand, accused number 2, Vijay or instead of Pramod Patil. Madam. I may permitted to correct this. Madam.
There's no.
61 we have adjourned because the
Party is absent.
not.
62, there's no stipulation as such.
Revenue entries shall remain as they were prior to the impugned order.
Yes, madam.
Till the disposal of the RSA. Have you kept them intact? No. Then you have to say that, but there is a direction. Page 11.
Yes.
Since RSA is pending against the decree in question, perhaps his suit is proviso to 135, section 135 KLR Act.
Yes.
Now RSA is pending there. And perhaps there is stay also. Therefore, learned judge said, till RSA is disposed of, keep the entries as they were before.
Please, I'll seek instructions, Lord. Notices not issued.
I may permitted to correct the name of accused number 1 and 2.
25th.
I filed
All together.
Please.
Respect of. You have not paid the process fee, you have to take
Madam,
steps.
since I went to the office, madam, since wrong number, name of the accused persons are wrong, madam. Therefore, I have constrained to file application. Thereafter, I have to furnish the application. In fact, process was ready, madam. When I went to office, unless it is corrected, against the wrong person, I couldn't do this, madam.
Other persons you want to implead.
No, madam, in fact, madam, the filing of the contempt itself, madam, the name of accused number 1 has been wrongly mentioned by me, madam.
Wrongly or some other name is mentioned.
Yes, madam, yes, madam.
Then it cannot be. You can't maintain, you cannot amend by way of bringing in some other person. You have to make a fresh petition. Otherwise, how can you amend the contempt petition like that? Not possible. Courts have held that way. You have to withdraw this and you have to, with liberty, you have to fresh proceedings you have to take up against the concerned person, not introducing some new party here.
Please, madam. Madam,
You have to withdraw that.
please, madam, with liberty to.
Advocate Mr. So-and-so stated that any of certain technical defect being crept in, he wants to withdraw the contempt petition. Further submitting that the liberty will be reserved to file fresh.
Fresh contempt.
Reserving such liberty. This contempt petition is disposed of or withdrawn.
Please.
December 63. Mr. Manjunath Prasad HN.
I'm appealing for the complaint, Lordship. I need 1 week accommodation.
Filed recalling the order, Lord. This was disposed of by the order of this honorable court.
This is a missing file reconstruction
Yes,
that you have undertaken now.
that we have undertaken, Lord, but there are no records at all in this matter. I have argued the appeal also.
But your end, the file is not over. The reconstruction.
The protocol for that, no? For
Yes.
reconstruction of lost files.
That's right. We have placed it before the committee. That process is going on, Lord. So far as this contempt is concerned, Lord, this was disposed of.
That's true, but let us see. Some application here said something.
Please.
1 week accommodation, I'll remove the office objection.
Number 64, Mr. T. Prakash.
That I represent the petitioner. 3 and 4, they have filed their the affidavit, but so far as 2 and 3 is concerned, they have not filed any objections as such.
I filed it on behalf of 4. It applies to 1, 2 and 3 also. Because we have not done, we have not demolished. His complaint is we have demolished. We have not demolished any one person. on
State
behalf of
authorities as well as municipal authorities have filed affidavits stating that, Lord, we have not demolished the compliance structure.
Who has demolished the
Millard,
subject
these,
structure?
Millard, they have, with the help of the police only, they have demolished. The photographs clearly
So
show.
they say we have nothing to do with that demolition.
Millard, Annexure C, Millard, the Gram Panchayat, without the instructions and the police cannot come there and they cannot demolish the building. It is they who have issued a
That
notice.
WP is still pending.
Yes, Millard. It's
Then
still,
work out your remedy before the learned single judge seeking reconstruction of the demolished structure under 151. Where
Yes, ma'am.
Justice Govind, but Honorable Chief Justice
Yes,
held long ago, decades ago,
yes, ma'am.
that where a structure has been demolished in violation of the court order,
Yes, ma'am.
you can make an application for rebuilding of the structure.
Yes.
Status quo ante.
Millard, it may be taken
Go,
up.
but how is an interim order? How can we hold?
Well, I will go through that citation and it may be taken up after.
Well,
vacation.
interim order, we are not interfering. You can bring that complaint before the same judge, saying that your order is violated and the building is demolished. We have already held that way. Otherwise, we would have entered.
I will go through that citation and.
No question of citation. It cannot go on like that. We should be fully
Withdrawing.
updated.
But that observation may be made, Millard.
Yes.
That will make. Realizing that order brought under the contempt jurisdiction, which is an interim order. And the proceedings of writ petition pending before a single judge, from a learned advocate, Mr. So stated that they would, that the complainant would approach learned single judge in the pending proceedings and take grievance about the non-compliance, about the breach of the interim injunction to stop. Such liberty is granted. It is permissible for the complainant to approach learn a single judge where the variant proceedings are pending to work out his rights in relation to the grievance voiced in this contempt. However, subject to above observations and the liberty reserved, the present contempt proceedings are not entertained and are disposed of accordingly.
Number 65, Mr. Gautam Basu.
In serial number 65, Lord, we have filed the complaints affidavit.
My lord, so writ petitions pass the order without expressing any opinion on the merit of the case. Though we filed a contempt petition, but we want to withdraw this case with a liberty to file a fresh writ petition because our issue was not passed on the merit.
So learned advocate, Mr.
Gautam Basu.
Takes permission to withdraw the present contempt petition. So permission is granted. Dismissed as withdrawn. At this stage paragraph, learned advocate requested the court to permit him to. What is the request?
On the merit, based on merit, without any merit, they pass the order.
No, we have considered their representation and rejected it.
And my lord,
If at all.
they
he wants to
submit
challenge-
one counterclaim, but they have mentioned the model rules of 2020, which was repealed. And in 2021, Karnataka government has came with a new rules where it was mentioned that member of a consumer commissions is entitled to get a salary of deputy secretary of the state. But presently the petitioner is getting salary reducing by his pension.
Now they have considered and issued, made an order. If you are aggrieved critically weakened, that endorsement dated 22/11/2023.
Yes.
That you have to put in challenge in regular jurisdiction. Our contempt jurisdiction is very restrictive. We cannot undertake critical examination of the orders made pursuant to directions. You challenge that endorsement, that liberty we can seek.
Okay. Annexure B, Madam, my lord, Annexure B, it is clearly mentioned 2021, Government of Karnataka under Section 102 of Consumer Protection Act, they make a model rules for pay of salary.
Because you have decided the representative.
Yes, yes.
Directions
As-
of
As per,
on a single judge in paragraph 6 of the order dated 6 July 23 was to require the respondent authority to consider the representations dated 7/7/22, 30th 8/22, 7/10/22, and 12/2/23 of the petition. Today, is stated by learned government advocate, decided as per endorsement of the order dated 22, which endorsement figures on record along with the compliance affidavit. To step in that in the aforesaid, the directions of learned single judge are complied with. As the decision is taken upon representation, the contempt proceeding does not survive, accordingly disposed of. At the request of learned advocate for the complainant, it is observed that the liberty is reserved for the complainant to challenge the decision independently in accordance with the rules. So this court, however, does not express any opinion on such recourse to be taken, which may be taken by the complainant.
My liberty to fresh file.
Yes.
Much more less.
66, Mr. Subramania Bhattacharya.
I appear for the complainant in this case, my lord. My lord, I have filed an application for recalling the order passed in contempt number 1215 of 2023, my lord. Because this petition was, contempt proceedings were dropped on the submission made by the counsel for the accused saying that they have sought for review petition. But have not come across any such petition, my lord. There are some office objection raised in this application. I'll undertake to comply the same, my lord.
Any review petition was filed?
yes, Lord, this
Is still pending.
it is pending. I think. The last may kindly have it next week, Lord, so that.
My lord, let them give at least a number, review petition number, my lord, because
I shall furnish.
Furnish, at least review petition number you have to give, na?
Yes, I made a submission on instruction.
24th.
Yes.
Lord, date,
24th June.
very well, great.
Seven urgency number 68, K.R. Ganesh Rao.
Well, as per police report, A3 is not working in that place. In his place,
Not south.
one TK Venugopal is working.
Service is awaited.
Sir.
First steps to be taken.
One TK Venugopal is working and he should be
68.
made a party member.
There was a respondent bank, my lord.
Since the endorsement is there, the service on the respondent is awaited.
And I'm
Oh,
making a
There
submission.
shall be fresh steps to be taken by learned advocate for the complainant.
Take fresh steps in respect of unserved respondent. Then we can take up the matter.
That to be amended, TK Venugopal is to be brought in. Because that earlier that A3, Rajiv Kumar, he is not found there. One TK Venugopal is
has been
working
transferred,
as per
madam.
police report.
Mr. Rajiv, who was the general manager, he was transferred, and in fact, he was not in charge of this department at all. The charge in department is one Mr. Venugopal, general manager. And that is,
As on the date, the content petition was filed.
yes, ma'am.
Was he in office?
He was in office, and his name was wrongly mentioned as some Rajiv or something like that. Then this was amended, and they made it as Ranjiv Sharma.
One
By that time, he
typographical
was
mistake
transferred.
is, my lord. One letter N is not typed between Rajiv Kumar and Ranjiv Kumar. For that one, IA I have filed. N is to be typed.
On that day, we received.
So Ranjiv Kumar is,
On that day, from Rajiv Kumar to Sanjeev Kumar.
so it is to be served to the Ranjiv Kumar.
On
Let us
that-
see.
On that day, on that. Till that, let the Rajiv Kumar be Rajiv Kumar.
Steps to.
No heavens will go into court.
Fresh steps to be taken.
That we have directed, take steps.
Date maybe.
26 June. Number 69, so Lokesh KV.
So it's await, notice is awaited, my lords. Appear for the complaint in this case.
Seventy.
70, Mr. Bipin Negre.
Petitioners. Government has to submit report. my lord.
March 2020. Kannada, my lord, if my lord could have it.
Seventy-one urgent, syllabus 72.
For petitioner in the matter, my lords.
Srikanth.
Lords, in fact, my lords, by order dated 9/1/2024, my lords, I was permitted, my lords, to serve on the principal of the institution, my lords, since, my lords, the 10th proposed respondent, my lords, refused to receive the hand summons. My lord, that has been served, my lords, on the principal. My lords, I filed the affidavit also, my lords, stating that, my lord, the proposed 10th respondent refused service of notice, my lords.
He refused to accept tender.
My lord, the principal, my lords, has received it.
Ah.
But my lords, whether he has communicated, my lords, to the concerned, my lords, that I need to verify, my lords.
All right. At the
Whereas, my
request
lords,
of-
personally, when we served, my lord, he refused to give the acknowledgement.
You want to verify, or you verified?
I filed an affidavit also, my lords, with regard to that.
After vacation.
Number 73.
Much obliged. My lord, there is some urgency in the matter, my lords.
After vacation.
Lords, on the reopening day, my lords, if my lords permit, my lord, about, my lord, the sports quota seat, my lord, in the medical college.
14 June.
14 June.
Greatly
Number
obliged.
73,
Appearing for the state, my lord.
case Nas Narayan Swamy.
Steps to be taken. Steps to be taken.
I'm not adequate for the apparent shall take steps to the answer response.
So last time notice was
Hand over
given
to
to bring the
25th
LRs on
of
record.
June. Yes.
Year 3 is
LRs
for
on-
bringing a loss.
Please, my lord,
Year 3 is for bringing a loss.
please.
Steps have to be taken.
Bringing a lot.
Yes.
Bring a lot.
Rectification of entries.
74. Mr. V. Anand.
Steps to be taken R1, lordship.
75.
Steps for certain of
Official
the
officer seniority.
certain.
Process has to be.
May,
Lord,
may I make submission, my lord? When order dated 11/10/2023, notice to R10, R17, 25, 40, 49 were dispensed with, my lord.
But there are other respondents.
No,
my lord, they have been served in the other appeal.
They are served
Yes,
in the
ma'am.
other
And-
related matter.
Yes, my lord.
And respondent number 4 is served through the caveator.
That my lord, Sneha M. Bhagwat will file wakala.
And my lord,
Mr. Pawnish G.
For them.
Pawnish D.
my lord, the
One
one,
second.
yeah.
For respond for who appears?
In my lord, 1162,
Ah.
R4, Ms. Pawnish D, my lord. Sneha Bhagwat will appear.
You are appellant in the connected matter.
Yes, ma'am.
So you will be taking notice for R4.
1162.
So accepts notice for respondent number 4. Then 10, 15, 17, 21.
My lord, they have been served in WA 1006 of 23.
No, do you take accept notice for
No,
them also? You
no.
do not. They are served now.
They are served in connected writ appeal.
In connected writ
Yes,
appeal.
lord. Therefore, my lord may say service may be sufficient.
Okay, ma'am,
At least you have to file a memo
No, I
saying
have-
that in the connected matter, these responses have been served.
I have filed a memo before your lordship. My lord, the memo, the order dated 11/10/2023 passed by your lordships.
That is in respect of 49 and others. But so far as 10, 15, 17, 21, 25, 39, 45.
My lord, respondent number 10, 17, 25, 49 has been dispensed wide order dated 11/10/2023.
10, 15,
10, 17,
10, 17,
25
25.
and respondent number 49 has been dispensed wide order dated 11/10/2023.
Yes, for rest of the respondents.
Rest, my lords, that is respondent number 21, respondent number 39 and respondent number 45. After filing of the appeal, they have retired from service and allowed to take fresh steps, or they may be kindly be dispensed with.
No, they will be necessary parties.
Then I'll take steps.
You have to take steps.
Steps with regard to 21, 39, 45, 15 and 51.
But they have been served in connected writ appeal.
No, in my writ appeal,
R21, Madhusudan B is R20 in WA number 1006 of 23.
That's true. But since they are retired, fresh steps need to be taken. In respect of 21,
39,
9,
45,
45 and 51.
51 and 15. Our
55
transfer
and-
act, 15.
If I may, I appeal,
Respondent 15.
may I appeal to your lordship in connected writ appeal,
You're
they are
right.
parties. They have been served.
That's all right, but in respect of
This,
this, they have retired. He has to take.
I'll take fresh steps.
Learned advocate for the complaint take steps to respect of service of notice to 15, 21 and 51. 15,
lord.
21 and 51.
My lord,
Well,
I'll appear for R7, my lord, in 1162.
15, 21.
39 and 51.
39, 45 and 51, 5 of them.
45 also.
45 also.
My lord, in 1162, I'll appear for R7, my lord. I undertake to file wakalat.
1162.
62 WA.
You appear for
R7, my lord.
or 7.
Yes, I'm already on record for R4 in the connected appeal.
Your name.
Yes, my lord.
But one date may be fixed, my lord.
Service act. Without service, okay.
No, my lord.
I'll take steps.
The difficulty is they can file a memo. There is a stay running against me.
Serial number 80, my lord, it is covered.
Interim order will be extended.
There is an order, direction to the respondent to release the arrears of salary and retirement benefits. Petitioner complaint, husband is taking cancer treatment, my lord, kindly consider.
We have passed.
We have meeting.
You have passed an order, my lord, I am filing of the
Please.
Serial number 83, interim orders may be continued.
All until.
Please.
Formally.